ಆಮೇಲೆ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಒಂದು ಕನೆಕ್ಟೆಡ್ ಹೇಳ್ತಾರೆ. ಇದು ಯಾರಿಗೆ ಹೇಳೋದು? ಇದು ಅಷ್ಟೇ ಆಗ್ಲಿಲ್ಲ, ಅವ್ರು ಕರೆದ್ರೆ ಬರ್ಲೇ ಇಲ್ಲ, ಏನ್ ಮಾಡೋದು? ಮತ್ತೆ ಇದು ಕರೆಕ್ಟ್ ಮಾಡಿರೋದು ಸರಿ ಇಲ್ಲ, ಆಫ್ ಮಾಡಿದ್ರೆ ಅದೇ ಸೌಂಡ್ ಇರಲ್ಲ, ಚೆನ್ನಾಗಿರುತ್ತೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಮೇಡಮ್? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಅದೆಲ್ಲ ಆಫ್ ಮಾಡುತ್ತೆ.
ಮಾಡ್ತೀನಿ ನಿಧಾನ ಮಾಡ್ತಾರಲ್ಲ ಆನ್ ಮಾಡಿ
ಬರ್ತವೆ.
ಇದೆಲ್ಲಿದೆ
Volume.
ಇದೆಲ್ಲಿದೆ ಇದು
ಅದೇ ಇದು ಇದೇನೆ ಅದು ಈಗ ಬಂತು ಬಂತು ಬಂತು
ಬಂತು ನೋಡಿ ಹೋಯ್ತು
ಇದೇನೋ ಆಯ್ತು
ಬಂತು ಹೋಯ್ತು
ಬರುತ್ತೆ ಹೋಗುತ್ತೆ ನೋಡಿ ಇಲ್ಲಿ
ಇರುದಲ್ಲಿ ಅಲ್ಲಿ ಎಲ್ಲಿ ಕಟ್ ಆಗ್ತದೆ ಇವೆರಡು ಅಲ್ಲಿ ಒಂದು ಸ್ಪೀಕರ್ ಆಗುತ್ತೆ
ಹೌದು.
ಸ್ಪೀಕರ್ ಹೋಗಿದೆ ಇದ್ರ ಮೈನ್
ಮಾಡೋದು ಸರಿಯಿಲ್ಲ. ಈಗ ಆಫ್ ಅಲ್ಲಿ
ಏನೋ ಮಾಡಿದ್ರೆ ಏನೇನಾಯ್ತು
ಅವರೇ ಬರ್ರಿ ಒಂದೇ ನೋಡ
ಎಲ್ಲರೂ ಮೂಟ್ ಆಗ್ತಿದ್ದಾರೆ.
ಟೆಕ್ನಿಕಲ್
ಮತ್ ಈಗ ಬಂದ್ಬಿಡ್ತಾರಲ್ಲ ಬೆಳಗ್ಗೆಲ್ಲ ಮುಗಿಸ್ಬೇಕು. ಈಗ ಯಾರೋ ಬರ್ತಾ ಇದಾರೆ. ಬಂದ್ರ ಅದೇ ಇಲ್ಲೇ ಇದ್ದಾರೆ. ಈಗ ಬರ್ತಾರ ಬರ್ತಾ ಇದಾರೆ ಬರ್ತಾ ಇದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಪೂರ್ಣಿಮಾದವ್ರು ಕಾಣಿಸ್ತಾರೆ.
ಲಾಗಿನ್ ನಮ್ಮ ಹೆಸರು ಡಿಸ್ಪ್ಲೇ ಆಗ್ತಾ ಇಲ್ಲ.
ಅವ್ರಿಗೆ ಮಾಡಿದ್ವಿ ಅವ್ರಿಗೆ ಮಾಡಿ ರಿಜಿಸ್ಟರ್ ಸೌಂಡ್ ಆಫ್ ಆಗ್ಬಿಡುತ್ತೆ. ಯಾರು ಬರ್ತಿಲ್ಲ. ಇಲ್ಲ ನನ್ಗೆ ಗೊತ್ತಾ ನಮ್ಗೆ ಏನು ಗೊತ್ತಿಲ್ಲ. ಇದು ನೋಡಿ ಇದು ಆಫ್ ಆಗಿ ಆನ್ ಆಗುತ್ತೆ ಮತ್ತೆ ಆಫ್ ಆಗೋಗುತ್ತೆ ಅಂತ.
ಬನ್ನಿ ಈಗ ಇದೈತಲ್ಲ ಇದು ಇದಕ್ಕೆ ಕನೆಕ್ಟ್ ಆಗ್ಬೇಕು, ಇದು ಆನ್ ಆಗ್ಬೇಕು. ಆನ್ ಆಗ್ತದೆ, ಒಂದ್ಸರಿ ನೋಡ್ಬಿಡಿ ಎಲ್ಲ. ಲೂಸ್ ಕನೆಕ್ಟ್ ಆಗಿದೆಯಾ
ಆಗಿದ್ದಲ್ಲ
ಈಗ ಸೌಂಡ್ ಬಂದಿಲ್ಲ
ಮಾತಾಡಿ.
ಮಾತಾಡಿ ಸರ್.
ಅಲ್ಲಿ ಮಾತಾಡ್ಸಲ್ಲ ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್ ಅಂತ
ಯಾರಿಗೆ ಸರ್ ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್?
ಹಾ ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
ಆಯ್ತು ಬರ್ರಿ. ಅದು ನಮ್ಮ ಮತ್ತೇನ ಬಂದು ಅದೇನ ಬಂದು ಎಲ್ಲ ಒಂದು
ಒಂದ್ ಸ್ವಲ್ಪ ಇದ್ಬಿಡಿ.
ಅದಕ್ಕೆ 2 ನಿಮಿಷ ಇರಕ್ಕೆ ಹೇಳಿದ್ದೆ.
ಹೇಳಿದೀನಿ. ಫಸ್ಟ್ ತೆಕ್ಕೊಟ್ರಲ್ವಾ ನಿಮ್ ಬಗ್ಗೆ ಪ್ರಿಂಟ್ ಫಸ್ಟ್ ತೆಕ್ಕೊಟ್ರು.
ಶುರು ಮಾಡ್ತೀನಿ ಇದೆ
ಅಲ್ಲ ನೀವೇ ಹೇಗೆ
ಯಾಕೆ ಇಷ್ಟು ಅಷ್ಟೊಂದೆಲ್ಲ
ಕರೆಕ್ಟ್ ಮಾಡಿದವ್ರೆ ನಾವು ಕೇಳಿದ್ರೆ
ಏನು ಸಮಸ್ಯೆ
ಶನಿವಾರ ಬಂದಾಗ ನಮಗೂ ಗೊತ್ತಾಗುತ್ತೆ.
ಅದೇ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ರೆ ಒಂದು ನಿಮಿಷ ಮಾಡಿ.
ಮೀಟಿಂಗ್ ಇದೆ.
I'm up for vacating stay, Your Lordship. Tomorrow, Lordship.
My lordship, seeking listing tomorrow.
ಯಾವ roster?
My lordship,
Which roster?
my lordship, this is a temple land being usurped by
LB or CS?
LB, my lordship.
Now LB will be taking up on Monday, Tuesday, Thursday and Friday. CS will be taken up only on Wednesday. So whatever you move will come on that day. Now all of you are subscribed to our Telegram channel?
Yes, my lordship. Yes, yes, my lordship.
ಯಾಕೋ ಡೌಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದೀರಾ? Now yesterday we have put up two documents have been put up if you have noticed.
Yes.
One is the orders matters in LB, two is orders matters in CS. Adella it is as regards compliance of office objection. We will not be listing any office objection matters, orders matters, we won't waste time in that, we will directly go to final hearing and B group. Orders matter, you comply it in the office, the list is there, it is segregated with advocate name, case number, advocate name, what is the compliance to be made. I'll know that in compliance, most of it is process fee. Second, non-compliance of office objections. Third, IML non-service of copies. ಅಷ್ಟೇ ಇರೋದು. ನೀವು ತೆಗೆದು ಅದು ಮಾಡಿಬಿಟ್ರೆ there are nearly 1,000 matters in orders for LB. They are lying from 2017-16 in the orders. So if you complete it, well and good. If there is nothing in the matter, 3 weeks and the time fix ಮಾಡಿದೀವಿ. It will be listed on 23rd insofar as LB is concerned. If not complied, dismiss. 3 weeks is good enough to make payment of process fee, serve copies and whatever compliances ಮಾಡಿಬಿಡಿ. ಏನಕ್ಕೆ ಕಾಯಬೇಕು? Just finish it, you have the list. We understand every time we'll forget, but now this is not going to be forgotten because it's there in the list. It is by petitioner's name, it is segregated. So ನೀವು ಅದು ತೆಗೆದು ನೋಡಿದ್ರೆ petition name ನಿಮ್ದೇ ಒಂದು 15 ಇರುತ್ತೆ, 15 ಮಾಡಿಬಿಡಿ. ಒಂದೇ ದಿನ ಹೋಗಿ ಮಾಡಿಬಿಡಿ. It won't take much time. ಅದು ಮಾಡಿಬಿಟ್ರೆ CS will be listed on 22nd, same story. ಅದನ್ನು ಬಟ್ ಅದಷ್ಟೇನಿಲ್ಲ, ಅದೊಂದು 200 matters ಏನೋ ಇದಾವೆ ಕಂಪ್ಲೈನ್ಸಸ್ಗೆ. ಬಿಕಾಸ್ ಕಂಪ್ಲೈನ್ಸ್ ನೀವು ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ ಕ್ಲೈಂಟ್ ಬರ್ತಾ ಇಲ್ಲ ಕ್ಲೈಂಟ್ ಇಸ್ ನಾಟ್ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇನ್ ದ ಮ್ಯಾಟರ್. ದೇರ್ ಇಸ್ ನೋ ಪಾಯಿಂಟ್ ಇನ್ ರಿಟೈನಿಂಗ್ ದಟ್ ಮ್ಯಾಟರ್ ಇಫ್ ನೀದರ್ ಯು ಆರ್ ಇಂಟ್ರೆಸ್ಟೆಡ್ ನಾಟ್ ದ ಕ್ಲೈಂಟ್ ಇಸ್ ಇಂಟ್ರೆಸ್ಟೆಡ್. ಅನ್ನೆಸರಿ ಲಿಸ್ಟಿಂಗ್ ಅಂಡ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಬೇಡ. ಸಪೋಸ್ ಆಮೇಲೆ ಏನಾದ್ರು ಬಂದ್ರೆ ರೀಕಾಲ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ವಿಲ್ ಕನ್ಸಿಡರ್ ಇಟ್. ಅದುವರೆಗೂ ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಡಿಸ್ಕಸ್. So Monday, Tuesday, Thursday, Friday would be LB, Wednesday would be CS. And if you move ಮಾಡ್ತಿರೋ will come on Thursday.
One submission. The LB matter, the urgency is that this is the temple land, urban land, which is being usurped by the BBMP. It's the nature of the land, there's a little bit of change of nature of the land, my lordship. We are moved.
You have served it on the BBMP council?
I'll serve it right away.
Sorry.
I'll serve it right away.
My lords, these matters are covered by your lordship's recent judgment, my lord. He stated that a landowner is not required to give relinquish land free of cost.
Thursday.
Tuesday, tomorrow, Monday, some
ಏನು ಅರ್ಜೆಂಟ್ ಅಪ್ಪ 2 ದಿನ.
kindly, my lord, tomorrow,
ಅಂದ್ರೆ ಏನಿಲ್ಲ.
tomorrow, my lord.
The petitioner has challenged the reservation made by the government for the post of mayor to respond number 4.
Thursday na
Tomorrow maybe, my lord, because election is fixed on 4th.
election. Okay.
Please.
Serial number 5, the board petition has
We will come to the adjournment. mentioning matters.
Urgency is that your lordship, you are satisfied with the BBMP, they have come and put up a construction right in front of my door. 2:30, your lordship.
Tomorrow.
Your lordship,
Today, no?
because they have put up construction
Today?
blocking my entrance, your lordship, on the road,
2:30.
please.
But I should notice for demolition, we have already obtained 50. Like maybe had tomorrow.
Tomorrow.
Kindly, my lord, the no confidence motion has been stayed by this court. No confidence motion, my lord, has moved. And same was stayed by this honorable court, my lord, on the ground that the 14 days notice was issued instead of 15 days. Here, my lord, matter was listed on Thursday. Not reached, my lord, date is given to today, but it's not listed to today, my lord.
Dated to whichever. Bench in date ಕೊಟ್ಟಿದ್ರೆ ಆ ಡೇಟ್ ಲಿಸ್ಟ್ ಆಗಿದೆ. ನಾವು ಕೊಟ್ಟಿದ್ದಾರೆ ಲಾಸ್ಟ್ ಬೆಂಚ್ ಏನ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರೆ tomorrow. Yes, on the VC.
Records.
Secure direction ಕೊಟ್ಟಿದ್ದಾರೆ.
Last time they should.
Secure.
My lord,
Yes, on the.
Number 2 minutes.
Adjournment ಕರೀತೀವಿ ಒಂದ್ ನಿಮಿಷ ಅಷ್ಟು ಪಾಠ.
yes, fresh matter, my lord, challenging the joint register order, my lord.
Yes,
Yes,
Wednesday.
please, my lord.
Page number 4, serial number 19 and 20. Page number 5, serial number 21 to 28.
Serial number 27, drawing the.
This for final disposal. And we have to next week.
ಎಲ್ಲ ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಬರೋದು. Orders we won't list now.
Old matter, I could not able to say.
All old matters only will come.
I have a respondent, my lord. Only 2 days accommodation.
Have you informed the petitioner?
Petitioner is there, my lord.
Inform ಮಾಡಿದೀರಾ?
Petitioner is present here.
My lord. Serial number.
The petitioner in 21.
Petitioner is present here.
Petitioner already, petitioner counsel ಯಾರು?
Council advisory ಕೊಟ್ಟಿದ್ದಾರೆ, I don't. Previous council.
There is no counsel now.
But new council has come on the country.
ಯಾರು?
They came to know.
ಗಣೇಶ್ ಕುಮಾರ್.
Nagesh Kumar is the given.
My lord, I appear for petitioner. Serial number 21, ma'am.
21. Any objection for an adjournment?
No.
Vijeta R. Nayak has entered appearance for the petitioner. Delete the name. Shri Ganesh. Respond number 1. Seeks for and is granted a week's time.
Serial number 27, we are withdrawing the petitions.
27, learned counsel for the petitioner has filed a memo dated 7/2/2023, which is being signed by the petitioner and the counsel for the petitioner, seeking permission to withdraw the above petition. The submission made by the counsel as well as is accepted. Petition is dismissed as withdrawn.
Number 6, serial number 29 to 35.
32, my lordship.
Yes.
The counsel for the petition is unwell, my lordship. We are seeking a visa accommodation. my
Have
lordship.
you informed the respondent?
So we will inform them right away.
Then no, please don't mention without informing the other side.
Sitting an adjournment. Lord.
You are appearing for whom?
Petitioner,
Have you informed the respondent?
try to inform, but.
Tried alla nadiyalla. Inform madre mention ಮಾಡಿ.
I.
Please don't mention without informing. Please don't do it at all. If you do it, then we'll impose costs. Don't please keep on insisting. I have not tried to bada. Inform madre mention ಮಾಡಿ ಇಲ್ಲಾರು mention ಮಾಡಬೇಡಿ.
Number 9.
Inform ಮಾಡಿದೀರಾ petitionerಗೆ? ಮತ್ ಇವಾಗ ಹೇಳ್ಕೊಂಡು ಮತ್ತೆ ರಿಪೀಟ್.
Page number 7, serial number 36 to 43.
Serial number 38.
ಅದು AG ಅವರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ. ಚೆನ್ನೈಯಿಂದ AG ಅವರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ. ಅದು 10 days.
ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
ಚೆನ್ನೈಯಿಂದ AG ಅವರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ.
ಚೆನ್ನೈಯಿಂದ
AG ಅವರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ ಮೇಡಮ್.
AG.
AG.
Why would Chennai AG want to appear here?
Intergovernment.
ASG.
ಅವರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ ಮೇಡಮ್ 10 days.
Inform ಮಾಡಿದೀರಾ respondent?
ರೆಸ್ಪಾಂಡ್.
38.
38.
Counsel for the petitioner submit that the additional solicitor general will be appearing in the matter, and he seeks for a date to be fixed. Relist on 14th March for hearing.
Serial number 42, my lord.
Hmm.
He'll inform my other side. Government, AG.
Yogesh Naik idare. Yogesh Naik inform ಮಾಡಿದ್ದೀರಾ?
Next week, my lord.
Inform ಮಾಡಿದ್ರಾ ಅವ್ರಿಗೆ?
ಹೇಳಿದ್ದೀನಿ.
See, when you don't inform, our counsel ಬಂದ್ಬಿಟ್ಟು ಪಾಪ ಕಾಯ್ತಾರೆ.
ಇಲ್ಲ.
Why
Actually,
we
I
are
am.
insisting on information is, ನೀವು ಬಂದ್ಬಿಟ್ಟು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಂಡು ಹೋಗ್ಬಿಡ್ತೀರಾ. 1 ಗಂಟೆಗೆ ಅದು ರೀಚ್ ಆದವಾಗ ಅವಾಗ ಎದ್ದು ನಿಂತಾರೆ. ನಂಗೆ ಹೇಳೇ ಇಲ್ಲ ಅಂತ. Why should they waste 3 hours of their time? ಒಂದು 2 minutes if you inform, ಅವ್ರು ಬೇರೆ ಕೆಲಸ ಮಾಡ್ಕೊಳ್ತಾರೆ. ನಾವು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಿ ಯಾವ್ದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಹೇಳ ಕೊಡ್ತೀವಿ. ಬಟ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಬೇಕು. ಅಂಡ್ ಅವ್ರು ಅಪೋಸ್ ಮಾಡಿದ್ರೆ ತಿಳಿಸ್ಬೇಕು ನಮ್ಗೆ. ಇಫ್ ಯಸ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ವಿಲ್ ಅಡ್ಜರ್ನ್. Any objection? 42 at the request of the counsel for the petitioner released on 14th March.
43, my lord. I have informed the petitioner. It's a report which I have to file.
Testimony.
Serial number 37.
37.
Of each time, government advocate.
Have you informed Mr. Prashant?
I've informed Mr. Prashant. Have to ask. I've informed. Have to ask.
Will have.
Have informed. Have to ask.
37 at the request of the counsel for the petitioner released on 14th.
That's serial number 23, my lord.
40.
I'm appearing for respondent number 3 and 4.
23.
Please,
What has to go back?
none R3 and R4.
Yes.
I'll have to furnish certain documents, my lord.
Have you informed the petitioner?
No, I'm not.
On the serial number 23.
Not the first time you are appearing before us.
Yes.
Serial number?
23, my learned friend made a mention, the petitioner may be directed to serve a copy of the writ petition on
No,
me.
you are also respondent. Nobody for the petitioner. Please wait. Yes.
43, my lord. I have
40.
informed the petitioner.
Yes.
It's a report which I have to file. It is ready. I need a week's time. I will be filing in the next 3-4 days.
43 learned counsel for respond number
3 and 4.
3 and 4. Submit that the report is ready. Shri S.N. Prashant Chandra, who is entered up for respond number 4, accepts notice for respond number 3 also.
Yes.
Submit that the report which is required to be filed is ready. Given 3 days time, the same would be filed after service on the other counsels appearing in the matter. Relist on 13th March.
Okay.
Page number 8, serial number 44 to 48. Page number 9, serial number 49 to 55. Page number 10, serial number 56 to 59.
58, my lord, serial number 58. Government is a father. I'm for petitioner, my lord.
Have you informed the respondent?
Government advocate. Government advocate.
Government andre inform ಮಾಡೋದು ಬೇಡವಾ?
There is no statement.
There is no statement. Mr. Somiyaji is there, Mr. Manivannan is there, Mr. Naik is there. Have you informed? Please don't mention.
Okay, I will.
Today, for the first time that all of you are appearing, we are saying,
Senior is
being liberal on that. ನಾಳೆ ಮತ್ತೆ ಮೆನ್ಷನ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ದೆ ಮೆನ್ಷನ್ ಮಾಡ್ದೆ ಕಾಸ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಲೈಬ್ರರಿ ಫಂಡ್.
Page number 11, serial number 60 to 67. Page number 12, serial number 68. List number 2, serial number 1.
I represent the petitioners, Lord.
Yes, Mr. Patil.
Lords, I think in this matter, you are at least you are appearing for the 7th respondent, Lord. I think, Lords, the private respondent.
Yes, one post before a bench of which SGRJ is not a party.
Okay.
This is coming from.
Lords, I think
No, we are only a drop bench for this.
I understand that.
Not coming before us.
Great.
And post before a bench of which SGRJ is not.
Great.
List number 1, order serial number 1.
Even for petitioner, sir.
Yes.
Lordship, pray for both the petitions to be clubbed together.
That is a memo you have filed, is it?
Yes.
The memo dated 6/10/2020 is accepted. The registry is directed connect WP 6578 of 2020 with above matter. Readings are complete.
So I'm a proxy for
Readings complete.
Say those. Connected matter disposed of.
Collected matter. Connect.
Connected matter is a PIL matter. PIL can't be connected here.
That's what I was instructed, Your Lordship. Both the matters.
Disposed, so there's no point in connecting a disposed matter. Whatever. It's already been disposed. You can't. The memo dated 6/10/2020 has been filed, seeking to club WP 6578 of 2020, which is a public interest litigation, which has already been disposed. Hence, the question of clubbing would not arise. Memo dated 6/10/2020 stands rejected. Relist on 13th for arguments.
Serial number 2.
Right.
Shekhar Shetty.
Mr. Shekhar Shetty. Also.
Serial number 3.
This case, I for the LRs of the petitioner, my lord. So I pray for
Yes.
2 weeks accommodation to produce the documents on at annexure A,
That
B.
they're supposed to produce as per order dated 14/6/2020.
It is true, my lord. In the meantime, the petitioner passed away. LRs were brought on record. So no, I was told they have applied one certified copy. They have not yet procured. So I pray for 2 weeks accommodation, my lord.
What are annexure A, B, and C?
That is the order impugned, my lord. That is the Gram Panchayat order.
Any dispute about A, B, and C?
A and B are sealed it. Annexure is sealed it.
You very tight. Even put
Those documents, it can be disposed of. Those documents can be disposed of.
Without that, it can.
Because the orders are without judicial.
Are you ready on the merits, Mr. Narayana?
No, my lord, no, I am having viral fever. So that is why I could not appear personally.
Give you 2 weeks time, get ready, please.
I will.
The request of the Somaji says certified copy and bad A, B, and C. You don't need to. At the request of learned counsel for the petitioner, relist on 14th March.
Grateful, my lord.
You're appearing for respond number.
Respond number 1. Respond number 2 was reported in the last date of hearing.
Sri Gaurav K.
Please.
Has entered up for respond number 1, delete Mohan Bhatt and S.C. Shivramu. Has that
Lords, I beg to appear for second respondent, my lords.
You are going to appear for their legal heirs also?
My lords, I'm representing for the second respondents. I have to get instructions on this, my lords.
Second respondent is expired, so you can.
Yes, my lords. The legal heirs have to be impleted, my lords.
Yes. So, do you have the details?
No, my lords.
If you can get the details, give it to the petitioner.
I will, my lords.
The complainant was 321 complaint. That is his role. Suppose that can be dispensed with and the matter may be considered for disposal.
So, smart. None of
one point for
2 weeks time is granted to bring to file necessary application to bring the legal opinion of deceased respond number 2. He lives on 16th March.
I appear for respondent number 7 in this case, madam.
Petitioner could
Yes, madam.
Also,
Number 6. LP.
also.
Number 7.
Already served. The petitioner submitted that he has served copy of IA-1 of 2022 on the counsels for respondent. Hence, office of petition does not survive for consideration. Yes, sir. ಇದು ಯಾರಿಗೆ which respond respond despite notice having been issued on 4 earlier occasions, notice was not served on respond number 3. Hence, IA-1 of 2022 has been filed by the counsel for the petitioner, seeking permission to take out notice by way of subservice by publication in Kannada Local Daily, Kannada Prabha, and in circulation in Bangalore. The same.
Rural.
Bangalore rural. Accepting the statements made in the said application, IA-1 of 2022 is allowed. Counsel for the petitioner is permitted to take out paper publication in the Bangalore edition of Kannada Prabha on or before. You on or before 23rd March, indicating the next date of hearing as 20th March, indicating the next date of hearing as 4th April. We list on 4th.
Serial number 8. SV Mukkanappa.
Paid the cost.
SV Mukkanappa has entered appearance for the petitioner, believes CT permission of that appearing for the petitioner. A memo has been filed by the counsel for the petitioner indicating payment of cost. The same is taken on record. Yes. Venkat Reddy, you are appearing now. TM Venkat Reddy has appearance for respond number 153. Delete the memo. Then repeat that appearing for the
Writ of mandamus to take action regarding the
Given the representation, my lord.
the next EMI.
Component 1 to 3. As per
complaints. In complaint,
the complaint, my lord, the fourth respondent constructed the illegal construct to the in respect of the land, my lord. That's why, my lord, the petitioner is given the representation to the respondent 1 to 3.
This court seeking
But taking steps, my lord, against the fourth respondent.
petitioner is aggrieved by inaction on part of respondents and non-consideration by the respondent of the representation submitted by the petitioner dated 3/12/2014 and 10/12/2015. TM Venkat Reddy, the counsel for the respondent submit
1 to 3, man. We will take action in accordance.
that the respondent will take necessary action on the said representations to complaints strictly in accordance with law by following the due procedure of law within a period of
2 months. 2 months.
2 months.
6 weeks. Copy.
6 weeks.
Copy over. Report because starting
6 weeks from the date of receipt of the copy of this order. The submission is placed on record. The respondents to act on a printout of the uploaded copy of this order without waiting for certified copy. It stands disposed.
Serial number 9.
Respondent 3 to 5 minutes.
Objection.
Already,
Failure to be stated correctly and number of days needed to be stated correctly.
already minute 2 times listed. They are taken time minute. Till today, they are not complaints.
Also,
I'm for responding.
Serial number 10. CS Satyanand.
petitioner.
On the last date, my lord, on the last date, third respondent was implemented. Accordingly, my lord, now I have received, I have served a copy on him. And
the BJ Somayaji, and counsel for respondent number 3 confirms receipt of a copy of the petition along with annexures.
yes,
R1 already ittala nimatra. Very R3 the extra.
R1 ಡೈರೆಕ್ಟ್ ಟೇಕ್ ನೋಟಿಸ್ ಮಾಡಿ 1.5 ವರ್ಷದಲ್ಲಿ ಅವ್ರು ನೋಟಿಸ್ ಕಾಪಿನೇ ಕೊಟ್ಟು
this is very unfortunate. I don't know. I don't
ಆರ್ಡರ್ ಶೀಟ್ ನೋಟಿಸ್
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ ಸರ್?
ಹೌದು
Angenilla. It is not like that. But I have not seen my learned friend. Anyways, I have served a copy on him now. Lord.
Somayaji ಅವ್ರನ್ನ
Last date, my lord, what had happened was R1, my lord, R1's order is not under challenge before your lordships.
R1 ಗೆ ಡೈರೆಕ್ಟ್ ಟೇಕ್ ನೋಟಿಸ್ 1.5 ವರ್ಷ
ಕಾಪಿ ಬಂತಲ್ಲ ರೆಡಿನಾ
ರೆಡಿ
ಕೊಟ್ಟಿನಾ
Next, our instructions ತಗೊಂಡು ಯಾಕಂದ್ರೆ this is a new
ಸೋಮಯಾಜಿ ಅವ್ರಿಗೆ ಏನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಬೇಡ.
ಅಲ್ಲ new one, my lord. It is in violation of the earlier orders of this court.
If he is ready, he is ready. Are you ready?
Let him take instructions and make it. I'll make my submissions.
ಬೇಕಂದ್ರೆ ಹೇಳಿ.
ನಾನ್ ರೆಡಿ ಆಗಿ ಬಂದಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ. ಯಾಕಂದ್ರೆ ಸರ್ವ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
both the councils are granted 2 weeks time to get ready, address their argument. Appeal is done 14th March.
I'm ready.
Rectification of office. A3 of 2020 served. So
Lord, I pay for the petition in this, my lord. I pay for a week's time to do the needful, my lord.
why do you need a week's time to make payment of process fee?
Corresponding number 1
ಯಾರಿದು?
R3, LRs of R3, my lord.
12 ಅಲ್ಲ.
12,
You are
my lord.
applying in 12, there is no LR. There is issuance of notice on ಯಾರು?
To notice to the LRs of the ಅವ್ರಿಗೆ ಹೋಗ್ಬೇಕು.
R3 na?
Yes, my lord.
And counsel for the petitioner seeks for and is granted a week's time to make payment of necessary process fee and furnishing copies. If needful is done, registry is directed to issue notice on IA number
1 of 2023.
1 of 2023.
1, 2, 3.
Named therein, returnable by 10th April.
Obliged, my lord.
Number 13. Yes, the headline.
The office is raising objections regarding filing of petitional application for recalling order dated 7/7/22. Is it permitted to file that application in week's time?
What is 7/7/22 abated?
7/7/22 actually, as against economically, it was dismissed. As against the line, dismissed ಮಾಡಿದ್ದಾರೆ. ಅವರು ತೀರೋ ಹೋಗ್ತಾರೆ.
So IA2 would be for setting aside abatement, alva?
ಹೌದೌದು.
That will be
Office says I have to file application.
not necessary. IA2 of 2022 has been filed to set aside abatement. In that view of the matter, the office objection raised that a separate application would have to be made to recall the order dated 7/7/2022 does not arise. Said the office objection stands rejected. Your notice, ಅಷ್ಟೇನ ಇದ್ದದ್ದು? Notice ಆಗ್ಬೇಕಾ? During the pendency of the above matter, respondent number 3 has expired. Issue notice on IA 1 to 3 of 2020, the person's name in IA 3 of 2022, returnable by 4th April 2022.
Fourth raja ಇದೆ.
Fourth raja ಇದೆ.
Raja ಇದೆ. ಆಮೇಲೆ notification ಆಗಿದೆ.
ಆಗಿದೆಯಾ? So third working, third to fourth, ಎರಡು ರಜನ.
ಎರಡು ರಜೆ.
Returnable by 6th April. ಅಂದ್ರೆ 5th to 6th ಅಷ್ಟೇ ನಾವು
ಅಷ್ಟೇ. Fourth.
6th April.
Serial number 14.
So earlier it was mentioned as secretary. So now we have rectified in the last.
Correspondent to
this case
ನೀವು ಫೈಲ್ ಮಾಡಿದ್ರಾ?
ನಾವು ಸೆಕ್ರೆಟರಿ ಗಂಜಿಗುಂಟೆ ಗ್ರಾಮ ಪಂಚಾಯತಿ
ನಿಮ್ಮ ಹೆಸರು ಇರ್ಲಿಲ್ಲ. MS ದೇವರಾಜ್.
I'm appearing for the MS Devraj.
Now I am for the petitioner.
This case, in this case, clarify.
I have already rectified as Panchayat Development Officer.
Malaship, in this case, I will clarify, Malaship. The respondent number 5 name is PDO, Malaship. They have stated in the caste title secretary. Last occasion, they rectify the caste title and they say secretary to the PDO, Malaship. I am filing the wakalat the only PDO.
The caste title.
Now PDO is the executing.
That is for respondent number 5.
5, Malaship.
5 is Panchayat Development Officer.
Yes.
Ganjigunte Gram Panchayat.
Earlier it was secretary.
So now ಇವಾಗ ನೀವು ವಕಾಲತ್ ಯಾರಿಗೆ ಹಾಕಿದ್ದೀರಾ?
PDO ಅಂತ ಹಾಕಿ.
ಮತ್ತೆ objections ಏನು?
ಅಲ್ಲ ಅವರು ರೆಕ್ಟಿಫೈ ಸೆಕ್ರೆಟರಿ ಅಂತ ಇರ್ತಕ್ಕಂಥ PDO ಅಂತ ಮಾಡ್ಬೇಕಂತೆ. ಕಾಸ್ಟ್ ಟೈಟಲ್ ಇರ್ತಕ್ಕಂಥ
ಆಟದ ಮೇಲೆ with the permission of the court in the last.
ವಕಾಲತ್ ನಾಮ does not tally. ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ The PDO Ganjangunta Gram Panchayati and modification. ಪಂಚಾಯತಿ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ಅಂತಾನೆ ಇದೆ, PDO ಅಂತಾನೆ ಇದೆ.
ಅಲ್ಲ ಇದರಲ್ಲಿ
ಕಾಸ್ಟ್ ರೈಟ್ ಅಲ್ಲಿ ಸೆಕ್ರೆಟರಿ
ಆಮೇಲೆ ಚೇಂಜ್ ಮಾಡಿ
ಆಮೇಲೆ
ಆದ್ಮೇಲೆ ಚೇಂಜ್ ಆಗಿದೆ.
So with the permission of the court in the last occasion, it was ordered.
Registry has raised an objection as regards the Wakalatnama filed by respondent number 5, found that the same does not match with the cost title. Counsel for the petitioner submits that post the filing of the Wakalatnama, since it is now the PDO who represents the Gram Panchayat, necessary changes have already been made in the cost title. Hence, office objection does not survive for consideration.
Was rectified.
Yes. Yenidu, ready na?
Any date in the next.
Point number 4 could have received Wakalapnama.
We list on 14th. Readings are complete?
Readings are complete.
Readings are complete. We list on 14th for final hearing.
Number 15, Sagar BB.
For the respondent number 1, your lordship. Sheet may not survive for consideration.
Did not survive.
Resolution ಮಾಡಿ beneficiary identify ಮಾಡಿದ್ದಾರೆ. So ಆ resolution na question ಮಾಡಿದ್ದಾರೆ. Now the meeting is already over. Beneficiaries were identified, your lordship, and the Akupatras was also issued.
But that is the challenge. How can it be enforced?
Moreover, firstly, the members cannot challenge the repetition, your lordship.
That is different on merits. If the challenge is that the meeting was held contrary to this one, it can't be infructuous.
269, there is an appeal provision.
Adella ಬೇರೆ. Infructuous ಅಂತ ಹೇಳ್ತಿರಲ್ಲ.
Just for the reason that already the Akupatras were issued.
Counsel for the petitioner seeks for and is granted a week's time to get ready and address his argument. Released on 10th March.
Number 16.
Therefore, the respondent do the cost imposed 25,000 on the PDO. Subsequently, it was waived off, your lordship. I have to take back the cost. Week's time, my lordship, I will withdraw the.
ಬೇಡ ಅಂದ್ರೆ ಇಲ್ಲೇ ಇರ್ಲಿ. You have deposited cost. ಏನ್ ಮಾಡಿದ್ರಿ? 25,000 ಹಾಕ್ಸ್ಕೊಂಡು.
ಅಲ್ಲ ಇಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಅಲ್ಲ.
Counsel for respondent number 2 to 4 submit that you will be making necessary application for withdrawal of the
application is not necessary. Already there is an order, my lordship. Please, your lordship.
Counsel for respondent number 2 to 4 seeks for 2 weeks time to withdraw the deposited amount. Released on 20th March.
Number 17, Mr. Muligar.
Filed application for taking permission to file substitute service for respondent number 3 and 4.
Who is there for Puttegoda? Yes, sir.
4 times.
Copy not served.
Notice to respond number
3 and 4.
3 and 4 were issued on 4 earlier occasions. However, service could not be effective. Hence, IA 1 of 2023 has been filed by the counsel for the petitioner, taking permission to take up paper publication in the newspaper.
Proceedings, Kannada daily newspaper, Bengaluru.
Proceedings, daily newspaper, evening.
Daily. Daily.
ಆ ನ್ಯೂಸ್ಪೇಪರ್ ಎಲ್ಲ ಕೊಡಲ್ಲ. ಒಳ್ಳೆ ನ್ಯೂಸ್ಪೇಪರ್ ಹೆಸರು ಹೇಳಿ. ಕನ್ನಡಪ್ರಭ ಬ್ಯಾಂಗ್ಳೂರ್ ಎಡಿಷನ್ ಚೇಂಜ್ ಮಾಡಿ. Sought for permission in daily Diganta so and so. The said newspaper not being but I changed the said newspaper not being a well-known newspaper. The same being brought to the notice of the petitioner. Notice could be that is in the publication, Kannada Prabha, Bangalore edition. The submission is accepted. Counsel for the petitioner is permitted to take out sub-service by way of paper publication in respect of respond number 3 and 4 in the newspaper Kannada Prabha, Bangalore edition on or before
15 days.
on or before 23rd March, indicating next date of hearing as 6th April, released on 6th April.
For disposal, serial number 18. Yes, sir,
Respondent BP.
7 and 8. Seat for short.
You ready now?
Already type karo, but Nandan abhyantarilla.
You are ready.
Please.
Mr. Prashant Chandra, you are ready?
My lord, I am ready because mine is a very small submission there. That is all. It is between the two of them, the neighbors.
So all the counsels are ready to address their arguments. Shri K. M. Somshekhara, Learned Counsel for response 7 and 8, seeks for a week's time to get ready and address his arguments. Released on 6th March, it's made clear that no further adjournment would be granted.
Vardaman Gunjan.
So Gunjal,
This case, my lord,
Challenge the virus.
yes, in this case, my lord, what is in the petition, the education institution, my lord. It sought for that the land was converted for educational purpose and it was being used for educational purpose, my lord. They sought for building of additional building for nautical sciences college, my lord. At that time, when they applied for the plan, a demand was raised as per Annexure K, my lord. That I should pay about
charges.
J at page 66.
Not settled.
Development.
It's all settled by the judgments already.
Settled, my lord.
2011.
This proposition is, my lord, the education institutions are not considered as a commercial, my lord. The definition is clearly stated, my lord. It is between the commercial.
That is what they are containing, my lord, as section 2B. See, they contains the commercial purpose, my lord. But what is the basis for arriving at that figure? Nothing is forthcoming.
Why are you considering education as commercial?
My lord, as per the definition itself, my lord, stated in the Town and Country Planning Act, my lord. They say that, my lord, the education institution is also considered as a, my lord,
PDC. Which provision are you referring to?
Lord. 2(1)B, my lord. May I read, my lord? Definition. Commerce means carrying or any trade, business or profession or sale, exchange of goods or any type whatsoever, the running of the, which in the view of the make profit, hospitals, running nursing homes and the infirmary dispensaries and education institutions, hotels and restaurants, boards and also not attached educational institutions and commercial shall be considered. Now that has been challenged, my lord.
Any judgment on this earlier? No.
No, my lord. In respect of 18(1)A is concerned, my lord, the judgment is there, my lord, that is upheld by this honorable court, my lord. My lord.
So we'll have to consider now whether education would be a commercial. Education may be commercial, but
the definition is very.
we'll have to encourage education.
Definition itself, my lord, that is the reason, my lord, the challenge.
A challenge, my lord. Look at the hospitals, nursing homes, infirmaries, educational institutions.
Hotels, restaurants.
This is for the limited purpose of conversion. No?
My lord, development is concerned. Conversion is already done, my lord. We have given the, my lord, at the time of the building plan submitted by the authority, my lord. Then, my lord, I will issue the demand notice under section 18 of the KTCP Act.
For
Section 18, my lord. Read with rules 37C.
what is your demand?
Lord.
Change of land use.
Development. Sure. Next year, K, my lord, full member.
18 is change of land use. Okay?
Please, man.
18 is change of land use.
No, my lord. Develop demand notice.
Demand notice consequent to change of land use.
Respect of my lord, that is.
So your conversion is occurred, 95 is done,
Please, please.
14 is done. Now 18 only you have issued a demand notice. Demand notice on higher fee because it is a commercial nature, considering education to be commercial. Now in which zone have you granted this change of land use?
Agricultural. In the agriculture zone, my lord. It's permitted in under the agriculture zone, my lord. Education institution is concerned.
Annexure K.
Please, my lord. 18. Page number 66, my lord.
66. Yeah, 66 is annexure Y.
That is
68 is 44.
my lord, twice they have written.
Normal 44 and 3.
ಕರ್ನಾಟಕ ನಗರ ಮತ್ತು ಗ್ರಾಮಾಂತರ ಕಾಯ್ದೆ 1961 ಸೆಕ್ಷನ್ 81 ಪ್ರಕಾರ ಆನೇಕಲ್ ತಾಲೂಕು ಸುಬ್ನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 63ರಲ್ಲಿ ಒಟ್ಟು 7 ಎಕರೆ ಗುಂಟೆ ಪ್ರದೇಶವನ್ನು ಶೈಕ್ಷಣಿಕ ಉದ್ದೇಶಕ್ಕಾಗಿ ವಿನ್ಯಾಸ ಮತ್ತು ಕಟ್ಟಡ ನಮೂದನೆಗಾಗಿ ಸಂಬಂಧ.
You want to charge it as a betterment fee. What is the quid pro quo for this? What is the quid pro quo that you are? It's a fee, not a tax.
Development, my lord, is concerned, my lord. The 18-1, my lord, they already honorable held that, my lord. It can be, my lord.
Can be, but you'll have to show what you have done. Improvement charges matter less. There you have to show that what are the activities that you have undertaken which benefit this particular property.
Not in respect of, my lord, we have development is concerned, my lord. 1/3 share is required for will give to the UD, my lord, under development authority, my lord. 1/3 share is, my lord. In respect of that is concerned, my lord, they will utilize that amount, my lord.
So Gunjal, what kind of an organization are you? Are you a trust, charitable society, not for profit?
No, my submission, my lord, we are not sought for change of land use. We are not come within 14, 15, my lords. What it says is, my lord,
Yes, please. You are ready with the matter?
we are not approaching 14A, 14B or 15, my lords.
You not made an
We
application.
are not made application 14A, 14B. We are only sought for building this thing which was already converted for education purpose. And when it was previously, he was not, my lord, the court directed them to produce the land use map, my lords, how it is, Anekal Town Authority has demarcated this portion of the area. That plan they had to place, my lords, once when it's argued.
When was the direction given? Was there a direction, Mr. Yogesh?
Planning map, land use change act, that's what they will have to, the first approve, my lords. I'm not saying, if it is not for change of land use, my lord, it's already converted purely for education purpose.
Land, my lord, it's not land use, my lord.
I'm not seeking land change use.
Its building plan is concerned, my lord. Section 15 of the.
ATP not produced. Master plan.
ಯಾವತ್ತು ಡೈರೆಕ್ಷನ್ ಯಾವತ್ತು ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ?
It was orally informed, my lords, it was directed to be produced.
Orally we can't say. If there's a written direction, you can mention that.
when I approached my lord on what basis they calculated my lord, I was furnished with annexure B and C. You may kindly see. Regarding modifications of betterment charges stipulated by the BMRDA authority under section 10 and fine for violation. Government number so and so. The government law prescribed development fees burdens are 11.3 of the BMRDA Act. 11.3 means what the grant comes to the government, what the amount is granted by the government. 11.3. The state government shall every year make a grant to the authority of some equivalent to administrative expenses of the authority till authority is able to meet the expense out of its own resources. So that is how they claim under the refix the this is my note. Fee for approval of layout building plan.
Mr. Gunjal, just a moment. The land has been converted from agriculture to non-agriculture. What purpose?
Education is purpose.
Education purpose. Now the zoning regulation indicate this land to be what?
Zoning regulation indicates, my lord, for the earlier, my lord, the agricultural zone. In the agricultural zone it's concerned, my lord, the education purpose can be used for that, my lord. That is the reason, my lord, we have given a permission to develop the land. Then, my lord, he under section 15 of the KTCP Act, my lord, he filed the application before the planning authority to develop the land in respect of building is concerned. Then, my lord, we have issued the demand notice of that is concerned.
What basis have you issued that? You issued, yes, we understand. But what is the basis of exercise of that power?
37, my lord, the KTCP Act, planning is, my lord.
37.
Rules.
15 proviso, my lords, provide land use, change in land use of the development of which permission was sought is conferred with the master plan and regulation finally approved to section 3 of section 13. Now this change of land use map is to be, is, my lord. This is what is
37, my lord, the A, my lord. The fees of levy certain cases pertaining to change in the use or development building. Planning rules.
Yes.
1965, my lord. The fees of levy in the certain cases of the permission for the change in land use or development in the land or building, my lord.
So there has to be an application for change of land use.
Building also, my lord. Or building.
Permission to change in the use or development of land. If the fee has been collected for change of land use, the fee shall not be collected for development. Education institution, health institution, and any other public and semi-public buildings run by private individuals and institutions are to be treated as commercial uses except those specified in 1. Other purpose including charitable reviews and philanthropic institutions, non-profit nature. They are a charitable institution. So they come under exception under note 1. Table 2, note 1, Nodi.
If case is approval of and obtained section 17, have paid the fees approval under section 15, the same place exempted from the payment of the fees. Additional grant
Table 2.
Note, education institution, health institution.
The first one is as regards change of land use. Table 1. Table 2 is as regards fee per square meter of sanctioned floor area. Without getting into that, you see note 1, non-profit nature, you can't levy.
Respect of that, my lord, I will clarify.
In clarification of argument and argument. The notes are, the provision is very clear.
But commercial is concerned, my lord.
Note 2.
Please, education institutions, health institutions and other public and semi-public building are run by the private individuals and institutions are to be treated as commercial use except the specified in the note 1.
So charitable, religious, philanthropic institution of non-profit nature. Are exempted from this.
Respect of my lord.
What is a charitable institution?
Charitable institution is concerned, my lord, there is no specific title stated, my lord. In the definition is concerned, my lord.
Exercising these powers under 37A. Please. Now, 37A does not give you the power to levy this on charitable, religious or philanthropic institutions of non-profit nature. If it is a profitable nature, you can levy. Non-profit, you can't levy.
Small accommodation, my lord.
In fact, just Jagath. After arguing for some time, the Yogesh Nayak, learned counsel for respondent number 2 and 3, seeks for a short accommodation to obtain instructions on the applicability of note 1 and note 2 to table 2 of Rule 37A of the Karnataka Planning Authority Rules 1965, by virtue of which it is indicated that for organizations which are charitable, religious and philanthropic institutions of non-profit nature, the fee under Rule 37A cannot be levied. Fee list on 2nd March at 30 p.m. For further use. 20.
Hearing for the respondent. Petition copy has not. Oh dear. Now requesting from the last.
21. When did you appear?
The respondent 2 directly. He is the LR of respondent number 2A.
In WP against which petitioner is dismissed as abated?
Mr. R.
Petition number 1 and 2.
Petitioner.
In petitioners is there?
3 and 4. They are all brothers.
1 and 2 is dismissed, so only 3 and 4 are there.
Halagappa is there, someone. Respondent number 2 is there. Petition number 2 is there. He's alive. Only respondent petition number 1.
1 and 2.
1 month. 2, 3, 4 are they are alive.
Petition number 1 and respondent number 2 have died.
2 is dead. I have brought LR respondent number 2.
Respondent number 2 has now come on record. You have not given him a copy.
No, I have in the last time told this from your Lilla. You are
Kodi.
I got things. I will give him no one.
I give a copy.
No, 3 days.
Bari petition allappa annexures kodu.
I annexures xerox ಮಾಡ್ಕೊಡಿ. ಈಗಲೇ ಕೊಡ್ತೀನಿ.
I pass over ಕೊಡಿ. ಕೊಟ್ಟುಬಿಟ್ಟು ರಿಪೋರ್ಟ್ ಮಾಡಿ.
21 adjournment 22.
My lords, I represent the respondent in 21, my lords.
21 was adjourned, Mr. Prabhakar,
Okay.
at the request of somebody who indicated that everybody has been informed.
No, my lords.
No, we have not been informed.
Yeah, I have not been informed. Okay, my lord, I do not want to much deliberate on that.
No, we don't. 21. When the matter was not called out in Seriatam, Shri D. Prabhakar, Learned Counsel for Respond number 4, and Shri M. Vijay, Learned Counsel for Respond number 2, submit that they were not informed about the mention for an adjournment. The said submission is placed on record. Yavati idema?
13th March.
13th March kida.
Much of it.
We won't disturb the date, but next time we'll see what is to be done.
Yes, please.
Serial number 22. Repeat Hegde.
I have the petitioner.
Yes, Mr. Hegde.
My lord, I filed an application for plan sanction, my lord, in respect of 21 acres, 23 guntas. The plan, my lord, was sanctioned on 26/12/2007. But at that time, my lord, there was no master plan in the Bangalore International Airport Authority, was not formed. The master plan came, my lord, only in, my lord, 27/1/2009. So, my lord, before the master plan was approved, we had got a sanction of the layout, my lord, which has to be formed. Subsequently, my lord, we filed an application for modification of the layout. That application, my lord, as per Annexure E, now, my lord, has been rejected. Their contention is that, my lord, Annexure E, lost my candidate onto Annexure E. Page 22, my lord.
So when you seek for modification, what the master plan is applicable?
My lord?
Whatever the master plan is applicable as on that date?
Yes, my lord. The master plan says I am entitled to 50%, 55% of the residential area. What I have taken was only 49 point change. So, my lord, I gave an application saying that I am entitled to 55% as on the date of filing application also, and subsequent to the master plan coming into force also, I am entitled to 55%. Please give me the modified plan.
When you applied for in 2007?
Yes, my lord. I was entitled to 55%. 55%. My lord, there was a confusion, my lord, in the planning authority itself as to what will be the, my lord, percentage of development which could be given. Therefore, my lord, they had directed us to file an application for less than 50%. My lord, there is no dispute as to the fact that, my lord, I was entitled to 55% then. Then after the master plan came into force also, I was entitled to 55%.
When did you make your application?
My lord, in 2013, my lord, I'll give you the date. 29/4/2013 is the order which has been passed, Annexure E. 13/2/2013, my lord, is an application filed for month. 13/2, my lord, Annexure.
When was your first application?
First application, my lord.
Layout plan sanction.
Layout plan was sanctioned on 26/12/2007.
When was the application?
Application, my lord, I do not have the date of it.
But what was the rule applicable as on that date?
As on that day, my lord, there is no dispute as to the fact that, my lord, they have also stated in the statement of objection, I was entitled to 55%, but you have filed application for 50%, therefore we have given 50%.
What happened to the balance 5%?
My lord, the balance, my lord, was relinquished towards the road and the CA sites and parks.
It's already been relinquished.
It has been relinquished. Now their contention is, yes, you are entitled for modification of plan in respect of everyone, they say, but the cases where relinquishment deed has already been done, we cannot do it.
So now by virtue of your prayer,
yes,
the roads and civic amenities will be reduced by 5%.
My lord, we have given a plan in such a way the roads will not change at all. Park, my lord. The park area, my lord, as per the new master plan also, what is the, we are, my lord, going as per the new master plan itself. We have not changed the road aspect at all.
Yes.
My lord, 55%, we have now sought for 54 point change %, which we are entitled to.
So now the reduction will not be in the road, but will be in
Yes, my lord.
the civic amenities and open spaces.
Yes. Park, my lord.
Parks and open spaces.
There is no civic communication. First of my lord, I have filed a memo. They given wish only park and my lord CA sites, roads, my lord. CA sites not relinquished at the time of application, my lord. There is no such provision in the.
Now he wants to apply the new rules. So whatever the new rules, you'll have to do.
My lord, as on that day also I was entitled to. Now also I am entitled to. Now they say just because a relinquishment deed has been done, you cannot do it. But in respect of others who have not done the relinquishment deed, they are entitled to. Yes, ma'am.
Now, roads, you say you are not making any change.
Yes, ma'am.
There
No, yes, ma'am.
Three other components.
Yes, ma'am.
One is the open space, two is the civic committees, and three is the parks. Now, what is the percentage which was required to be left?
Yes, ma'am.
In the year 2007 for these three components?
Yes, ma'am.
And what is the requirement after 2009 when the authority came in?
Yes, ma'am. My lord, earlier, as far as civic community site, my lord, it was not mandatory.
Earlier CA not mandatory.
Not mandatory. Therefore, my lord, we have not left it.
Zero.
Zero. In respect of others, my lord, we have left 45%. That is road and open spaces and park.
Road you again problem ಇಲ್ಲ. Park.
Park
ಇವಾಗ civic community 10% to parks 10%, 5%.
Yes, my lord.
Open spaces. Civic community.
Lord, earlier I had left park 19.88%.
19.88%.
Road 30.13%.
30.13%.
And residential, which was approved, was 49.99%.
Residential was 49.99%.
Because there were certain.
Now, as per the modified.
As for the modified rules, mandatory, my lord, is for park and playground, my lord, below 10%, 10% and below.
Chapter 7.
Chapter 7. 10%.
Parks and open spaces.
Park and playground.
Open spaces.
10%.
Parks and open spaces is 10%.
10%. The balance area of 10% has been proposed for utilization. Road.
Civic community is.
Civic community 10%. 10%, my lord. Section 17 only.
10%. Chapter 7.
But as per the zonal regulation, my lord, 5% total area reserved for the vehicle parking and shall be parking in a zonal regulation. 10% of not for the open space.
5%. There is no parking for the layout approval.
Development of 20,000 square meters and above. The layout you can't prescribe parking. The layout you can't prescribe parking.
Lord, in page 24, what we have stated is, if I may read, page 24, paragraph 5.
24.
Paragraph 5. Zonal regulation allows 55% maximum of total area for residential purpose and 45% for roads, parks and playgrounds and civic amenities. And out of 45% of area so reserved, parks and playgrounds shall be not less than 10% of the total area and balance reserved for roads and civic amenities. Keeping this zonal regulation in mind, we have taken away 9.80% of the area of 19.88% earmark.
See what the zonal regulation actually says.
Yes.
Is your interpretation.
Yes, sir.
Zonal regulation.
They do not dispute as to this fact. They are only.
That they dispute, you don't dispute.
Yes,
what is the zonal?
Yes.
Chapter 7.
10% is parks and open spaces. 5% is for civic amenities. Residential development. Residential development plan.
Yes, it is. So 10% park, my lord, 5% CA, road 30% and 55% is up to 55% is for residential.
ಯಾವ್ದು ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು?
Page 880. 880.
Regulation?
There you go. Whole of residential layouts. Whole of residential layouts. Page 880. Whole of residential layout and heading.
The plan for biopharm. This is after the biopharm came into force. %10% will be parks and open spaces.
5% CA.
For CA.
30% roads.
%30 roads.
Incorporating major road must then the area under the road exceeds 45%.
Is there any major road shown in your layout?
No.
So it is the roads in internal roads only.
Yes.
So have you made provision for 10%?
Yes, my lord. That is what my lord stated in para 5 of my page 24, my lord.
And 5% civic community?
Yes, my lord. I have left that also in the plan which was submitted.
Lord, as per my submission, Lord, at that time, my lord, there is no dispute at all. Subject matter is concerned, my lord. My lord, there is a government order issued by the government, my lord, to give a direction to the authority. When my lord, the developer has been pushed to the all lands to the local authority, cannot be changed. My lord. I have stated in the statement of petition and filed, my lord, annexure A, my lord. Kindly, annexure R1, my lord, page number 6, my lord.
If there is an error which happened at the time of relinquishment.
Lord, after 7 years, my lord, made application for the authority, my lord.
R1.
R1 ನಲ್ಲಿ ಒಂದು circular ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ.
The government circular, my lord, should be inconsistent with the act. Now, they cannot just pass a circular and say, we will give modification in respect of everything, but only when relinquishment is done, we will not give.
Second paragraph.
Asking for modification as if a right mistake. So,
my lord, the section 17, my lord, of the act also says.
Submission, my lord. So, my lord, 76 sites has released, my lord. It has been also they sold by the developer, my lord. Now, my lord, without giving application from there, my lord, the entire layout, how can my lord modify the layout? Paragraph second, my lord. ನಗರಾಭಿವೃದ್ಧಿ ಯೋಜನಾ ಅಧಿಕಾರಿಗಳಿಂದ ಈಗಾಗಲೇ ವಿನ್ಯಾಸ ಅನುಮೋದನೆಯಾಗಿತ್ತು. ನಾಗರಿಕ ಸೌಲಭ್ಯ, ಉದ್ಯಾನವನ, ಬಯಲು ಜಾಗ ಮತ್ತು ರಸ್ತೆ ಜಾಗವನ್ನು ಇನ್ನೂ ನಗರಾಭಿವೃದ್ಧಿಗೆ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆ ಹಸ್ತಾಂತರಿಸದೇ ಇರುವ ಪ್ರಕರಣಗಳಲ್ಲಿ ಮಾತ್ರ ವಿನ್ಯಾಸ ಮಾರ್ಪಡಿಸಿ 50% ರಿಂದ 55% ಕೆಳಗಡೆ Here, my lord, they are already linked to the authorities, my lord.
I might say, my lord, so they have no objection, my lord, for modification of the plan if the sites are released also, but only question is, if the relinquishment is done, we will not release. That is their objection.
Parkal change ಮಾಡಲೇಬೇಕಾಗುತ್ತೆ.
My submission, my lord, is as per the section 17, my lord, when the plan is sanctioned, my lord, as per section 17, we will have to go as per section 17 of the BDA of the Town and Country Planning Act is concerned.
You already sold the plots.
Lord, we have sold certain plots. There is no dispute as
is going to get reduced.
Yes, my lord, as per the act itself. Now, my lord, they have.
As per the act itself is fine.
Yes.
So the park area is going to get.
Yes, my lord.
So the persons to whom you have sold will get.
My lord, your lords may kindly see the reasons in the order, my lord. They say modification can be done where even, my lord, sites are sold also. But one.
That is what they have said.
My lord, the circular.
The persons who are going to be affected will also have to be made parties. You want to make parties?
Lord,
they can't pass an order behind their back in your field. They cannot also do so.
My lord, they have been doing, my lord, in respect of all the layouts. Those sites have been released. That is my submission, my lord. That was recorded on the last occasion also.
RERA is also there.
Yes, my lord.
With the RERA coming in, any change in the plan has to be approved by 2/3 of the majority.
No, let them, my lord. If that is the reason which they have given, my lord, I can understand. Your lordship may kindly look into the impugned order which has been
Now
passed.
we'll have to see as on today's date.
Yes, as on today's date.
So today's date, RERA is also there, Mr. Agrawal.
Yes, my lord. Your lordship may kindly see the impugned order which has been passed.
That was before RERA, Mr. Agrawal.
Yes, my lord.
You are asking this order to be passed today. Today, RERA is also there. Whatever the law applicable will have to be made applicable. So the persons who are ultimately the persons who are going to lose out is the residents of the area in terms of their park area being reduced.
Yes,
you will be making more plots and selling. That is why you want it.
Yes, ma'am.
But their park area, if it gets reduced, which is what they have bought at that time, can we put our seal of approval on your scheme of things?
The only submission would be, my lord, by going through the impugned order, there is no reasons which have been assigned and they rely only upon the circular. Now, my lord, if you go into the circular, whether this circular.
If you want to make them a party, let us know. Otherwise, we'll record that you don't want to make a party.
That I will take instructions, my lord, now, because there will be more than 100 site owners.
They will be the people who will get affected.
I will, my lord, take instruction as to whether.
I'm not much concerned about you or them. The affected party.
Well, I understand, my lord. I will take instruction as to whether I will.
After arguing for the petition, or a counsel for the petition, seek for and is granted. So, condition of the definitive and counsel for the petitioner is that prior to the, at the time when the layout plan was sanctioned, the petitioner was entitled to 55% of the developed area, 45% being earmarked for road, paths, and open spaces. There being no requirement to earmark any land for the purpose of civic communities. Subsequent to the Constitution of Bangalore International. This is which one?
Bayappa. GIA.
Bangalore International Airport Development Authority.
Planning Authority.
Planning Authority. The entitlement has continued to remain as 55-45%. But however, there is a requirement of 5% of land to be earmarked for civic communities.
Comes on within 45%.
Which comes within 45%, which the petitioner is willing to do so. And as such, the reduction in the parks and open spaces by making available 5% for civic communities, as also complying with the, as also 10% specifically for parks and civic communities, parks and open spaces, is within the permissible limits, and as such, the application ought to have been considered. On inquiry as to whether the plots already formed have been conveyed to third parties. He submits that nearly 100 sales have occurred as regards the plots formed. He seeks for and is granted a week's time to obtain instructions as to whether the petitioner is willing to implead those 100 persons as party respondents, parties to this. Witnessed on 13th March. Take their consent and make them petitioners or respondents, your choice.
Very
Yes.
Just a week's accommodation method in this matter. We have to produce certain documents.
Sampath, you are now appearing for all the petitioners?
Yes, madam, I am appearing for all.
Sampath Bapat has entered appearance for the petitioner. Delete name of TM Manjunath, Anandeshwara, so and so.
Your Lordship, serial number 23, I appear on Shri R. Subramanya. We were directed to accept notice on the last date of hearing.
I have the, even all documents.
On the last occasion.
R2 ge kottilvante inna copies.
I will submit.
Yaವಾಗ ಕೊಡ್ತೀರಾ?
Again, the last hearing there, I had filed one memo along with 3 documents. They were not present on that day, therefore that was only that.
Or petition copy ne illa anta. They haven't filed wakalatnama as it.
They have filed NOC wakalat recently.
Your Lordship, on the last date of hearing, that is 22/2/2023, this Honorable Court directed us to accept notice on behalf of the respondent number 2.
Yes.
The petitioner has not served upon a copy of the writ petitions upon us, Your Lordship.
Agli other submission. Adjournment kedu illa. And counsel for the petitioner undertakes to furnish copy of the petition along with annexures on the counsel for respond number 2. ನಿಮ್ಮ copy ಬಂದಿದ್ಯಾ?
None, but I have received.
Counsel for respond number 3 and 4 seeks for 10 days time to get ready.
Yes.
Arguments. We list on 16th March. Or instructions ಬರೋಡಿಗೆ ಆಗಿದೆ.
Right.
Obliged, Your Lordship.
Endi ಓಂಕಾರಪ್ಪ?
Respondent.
Phone but you are for the petitioner. Where is Mr. Mohan? Mr. Mohan Bhatt is for the authority.
No, R2 appear, BP Manjunath. R3 is the private party. R2
Private party.
we have party. R2 I appear.
Where is he? Both of you are ready.
I'm ready. Yes.
We'll just pass over. Call Mr. Mohan.
25. M. Sivaprakash.
7th response. My lord, I am appealing for petition.
Yes.
My lord, I need a week's time. Senior is not feeling well.
Senior will be required to argue, but all these other things you can do. Why haven't you done all these things? Non-filing, non-amendment of the cost title. Senior ಬಂದ್ರೆ ಮಾಡ್ಬೇಕಾ? File or not? Pass over. Comply with all these things.
Number 26. Nagaraj Naidu.
In this case,
But there may be economic.
Why?
Because the arguing counsel is unwell, my lord. He has not been present before his honorable court. Next week, any date, my lord, it may be fixed.
You are appearing for 4 to 9.
Please, my lord. 4 to
10 to 9 is Mr. Shriyari. And Mr. Ashwatthappa is appearing for whom?
R9.
See that. 19. Counsel for the petitioner is present and ready to address arguments. None appears for respond number 10 to 19. Counsel for respond number 4 to 9 seeks for a week's accommodation to get ready and address his arguments. Relist on 13, it was made clear that no further adjournment would be granted if respond number 10 to 19 were not represented. The matter would be taken up for consideration in their absence.
Serial number 27 dismissed. 28. $29.
Suffering for the petitioner, my lord. Petitioner challenging the order partial notice issued by the respondent number 1 and 2 as per annexure H&J, my lord. H&J, my lord. Page 105 and 106, my lord. Reviewed by the said order, we filed appeal before KAT, my lord. KAT also dismissed the application filed by the appeal filed by the
21-1.
my lord.
Yes. KAT is already dismissed.
Yes, my lord. It's a contention is that, my lord. It's in, as per annexure E22, my lord. The measurement of the building is 400 square feet only, my lord. As per 7.2 of the building bylaws, my lord. The license is not required for the petitioner's concern, my lord.
Yeah, the last one.
Lord, now it is a new contention they are taking. Till now, there is no plan. Now, in before the KAT also, it is only first time they are taking this contention. Once they see, because it was in the CMC jurisdiction, and there was a complaint, and even otherwise there is a complaint that the building is on the road. There is some complaint law.
Let him address the argument, then we'll come.
Please. The respondent number 3 has raised a contention that with regard to that site, my lord. As per his sale deed, my lord, the northern side is the road, my lord. We are purchasing the 2003 itself, 1998. We have purchased from the original landlord, my lord. For that concern, we have filed a suit before trial court. We succeeded in this suit. Then we have an injunction against the respondent number 3 as also, my lord. Now our contention is for suit for a permanent injunction against this, my lord.
Between both of you, whatever the rights may be. Now the issue is there a site? Where is the location of the site and what have you constructed? Have you taken permission for it?
No, it's a Bikada sites, my lord. They will not, BBMP will not issue license for that, my lord.
If they won't issue, and you can construct anything that you want.
And for as per section annexure E22, my lord. E22, which is issued by the respondent authority for that, my lord. It's an ACC roofs, even it's not a sheet house, my lord. It's not a roof house, my lord.
Temporary structure. Temporary structure.
Yes, my lord.
Temporary structure will be removed. Then you can make a after getting your plan sanction. Plan sanction to
7.2 for it is building bylaws, my lord.
Building bylaws.
ಸಪ್ರೇಟ್ ಕಳಿಸ್ತಾ ಇದಾರೆ ಸರ್ ಹೇಳಿದ್ರೆ ಎಲ್ಲ ಇಲ್ಲೇ ಇದೆ ತಗೊಳ್ಳಿ ನೋಡಿ ಇದೇ ಸಪ್ರೇಟ್ ಕಾಪೀಸ್ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಹೇಳಿ ಪರ್ಚೇಸ್ ಮಾಡಿ ಕೊಡ್ತಾರೆ.
The BBMP building bylaw.
Yes, my lord.
Municipal corporation. Which provision do you want to read?
7.2, my lord. No plan shall be sanctioned or residential detached building on the plot measuring less than 50 square meters or having width less than 6 meters, my lord. Our case, my lord, width is 18 meters, 18 feet, my lord.
No piece of land shall be used as a site for the construction of building under the following circumstances. Adರಲ್ಲಿ ಇದೊಂದು.
Yes, my lord.
So you cannot use it for a site at all.
Okay.
Why did you buy something which could not be used?
They buy a
This is
purchase
not
in 1993, my lord.
This is not even a layout which has been sanctioned. You have created your own subdivision on the revenue line.
Yes.
The whole purpose is for orderly development. ಹಿಂಗೆ ಎಲ್ಲ ಮಾಡಿಬಿಟ್ರೆ
Got to that, my lord, that chart. They have raised, the respondent number 3 has raised one more contention that we have put up construction in the road, my lord. That is the.
wherever it is going. The petitioner is seeking for the following reasons. The petitioner claims that the petitioners have purchased property bearing 47/2, Kaka number 61, measuring east to 75 feet and north to south 15 feet. From survey number 47/, from Bangalore for 18 of B. Narayanpura, now called as Vidayanagar, extension B. Petition number 2 is stated to be the absolute owner of.
Our notice has issued only in respect of item number, the petition number 2 concern, my lord.
47/2, Kaka number 61, measuring east to west 18 feet and north to south 80 feet, including residential house thereon situated B. Narayanpura, Kerala, Somsa. The petitioner claiming to be the owners of these plots contend that these plots have been carved out of 47/2, measuring 2 acres 9 guntas. The same being situated abutting to CMC Mahadevpura. Respondent number 3 raised an objection as regards the constructions are to be put up by the petitioner on petition number 2 on the above property on the ground that there is no plan sanction which has been obtained. The respondent number 2 authority notice under section 321(1) of the Municipal Corporation Act, calling upon the petitioner as to why action should not be taken against the petitioner for having constructed without obtaining the plan sanction. Reply has been given, the same not being acceptable. A confirmatory order was issued. It was challenged by the petitioner before the Karnataka Appellate Tribunal in appeal number 765 of 2009, which also came to be dismissed. It is in that background that the petitioner is before this court. The counsel for the petitioner submits that the petitioner was required to put up construction without obtaining plan sanction, since in terms of
7.2.
building bylaw number 7.2, there's no plan sanction which would be granted in respect of plots which are less than 50 square meters. That is less than 538.20 square feet.
Are having less than 6 meters. Your contention is less than 6 meters. Wait.
Or having less than the width less than 6 meters. In the present case, the width of the property being 18 feet, which is less than 6 meters. The permission would not be granted. Therefore, the petitioner went ahead and put up construction of a temporary structure which would not cause any harm or injury to anyone. He submits that this fact, the petitioner being the owner is not in dispute. The petitioner could not have been prevented from making use of his land for putting up construction. And counsel for respondent would however submit that it is for any person to put up construction only after obtaining necessary plan sanction from the concerned authority by compliance with the applicable laws. The same not having been done, the 321(1) notice has been confirmed and KAT has dismissed the appeal, which needs to be confirmed. Anything else? Heard. Council station.
And moreover, this is the 2003, my lord. Their building is older one. This is the bylaw is 2003, my lord. Their building is 93, 98, and the issues, notices have been issued.
The short question that would arise is, when there is a prohibition under the building bylaws, it prohibits sanction of plan by the BBMP from issuing any plan sanction. Could any owner of the property put up construction without plan sanction? The building bylaws have been formulated as to enable orderly development of the properties in the city of Bangalore, and it is but required for everyone to follow the same in its true letter and spirit. The petitioner cannot, on the ground that no plan sanction will be granted, go ahead and construct on the property without such plan sanction. The land being revenue land, there being no plan sanction, there being no layout plan sanction, the property is being subdivided at the whims and fancies of parties. The risk having been taken by such parties in such subdivision, it cannot now be said that the petitioner is deprived of the usage of the land because plan sanction will not be granted. It is for the petitioner to have complied with the applicable rules and only thereafter make an application for plan sanction. It should have been considered in accordance with law. In the present case, the petitioner cannot, on the ground that no plan sanction will be granted, put up construction on his own. I do not find any legal infirmity in the order passed by the KAT as said the petition stands.
My lords, in serial number 30, my lords, I am appearing for the respondent, my lords. So I seek for a short adjournment, my lords, day after tomorrow, my lords. So today I am not well.
Yes, for the petitioner, learned counsel for respondent number 1 and 2 seeks for a week's accommodation. If none were to appear for the petitioner on the next date of hearing, petitioner will be allowed to dismiss the non-prosecution. We list on 14th March. 14th March, man.
Obliged.
Serial number 31.
Petitioners, my lord, kindly adjourn the matter for a week, man. We don't have any updates with regards to the installation of boom barrier.
You don't have any update on?
Regarding the boom barrier, regarding the present situation of the boom barrier.
Present situation of what?
A boom barrier, there's a boom barrier installed in the
boom barrier you have challenged. Where counsel for the petitioner seeks for and is granted a week's time to obtain instruction, make a submission. If no submissions are made on the next date of hearing, the petitioner will be allowed to dismiss for non-prosecution. We will list on 14th March. If you don't get instruction,
32. Anil Kumar, yes.
Not keeping. You are appearing for respondent number
2 minutes.
Counsel for respondent number 2 is present. Counsel for respondent number 1 and respondent number 2 are present. None appears for respondent number 3. Counsel for the petitioner, arguing counsel for the petitioner is stated to be unwell and short accommodation is sought for, released on 16th March. 33.
Kindly pass on.
Pass on.
D group matter, serial number 34.
In this matter, cannot be seeking for compensation for the government taking over the land for building the stadium in Mysore. Our representation has been rejected on the ground that we have had a double advantage and that there has been elections that they have to file a relinquishment.
AG wants to. And the date may be fixed, my lord, so that AG wants to appear in this matter, my lord.
For whom?
For the government, my lord.
What?
State government's order has been.
1 to 5 patch.
But what is the requirement of AAG to appear in this?
Yes, what?
He represents state also.
ನೀವು ಮಾಡಿ ಏನಕ್ಕೆ AAG ಏನಕ್ಕೆ ಬೇಕು?
Originals have to be secured in this matter. Secured.
ಇದು ಬೇರೆ.
Two volumes. The date may.
Which AAG will be appearing?
Subramanian.
Yeah, counsel for respond number 1 to 5. Submit that Shri R. Subramanian, Learned Additional Advocate General, will appear in the matter. He seeks for a released on 13th March for hearing.
15th fellow?
13th.
14th or 15th fellow?
14th March. It is made clear that adequate representation to be made on behalf of the state to address arguments, considering that the matter is of the year 2012. One accommodation aspect.
Please. 35. Are we related?
For a week's time.
You are appearing for R1 to R. Devendrappa has entered appearance for R1 to R3, delete name of Sandeep Patil and V. Srinidhi. That appearing for R1 to R3. Yes.
Okay, for a week's time.
Okay. Submitted the arguing counsel is unwell. Unwell and Taidira.
Short accommodation.
Released on 14th March, it is made clear that if arguments are not advanced on that day, petition will be liable to be dismissed for non-prosecution. But illa 14, everybody senior here. If he doesn't argue, it will be dismissed.
36. Then
I beg to appear for petitioner, my lord.
Again, the same issue. Town Planning Authority, Assam served, no representation. Earlier, CEO Mangalore served, no representation. CDO served, no representation.
The list of the advocates who are appearing for the authorities.
Last, Madidwala.
I have the numbers, my lord. I have to give the list, my lord.
Each Gram Panchayat, each Zilla Panchayat, each.
It has to be.
Webhost ಆಗಿದೆಯಾ?
I will get instructions, my lord.
ಆಗಿಲ್ವಾ?
I will answer most. I'll get because purely my lords has directed. I know.
Again, the same thing.
But you usually most of the authorities appear, my lord. Higher matters they will be changed, my lord, because 2016 several councils has been changed. So as a CEO, I'll give a new list, my lord. I have the new list.
Issue notices to them and they can.
Please, my lord, I'll give the new list.
And we'll web host it also.
Please, my lord.
And most of these authorities now have submitted their application for registration.
Yeah.
Town Planning Authority. If they have not submitted, let them submit so that they'll get.
I'll inform. I'll inform.
All the information is coming alive. Okay?
No.
Daily orders, judgments, everything is going to the authorities. So if these also are done.
What to 5 days, Jilla Panchayat and Taluk Panchayat appearing.
ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ರೆ ಲಿಸ್ಟ್ ಕೊಡಿ ವಿಲ್ ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಂಡ್ ವಿಲ್ ರೆಕಾರ್ಡ್ ಯುವರ್ ಅಂಡ್ ದಿಸ್ ಒನ್ ದಟ್ ಯು ಆರ್ ಗೋಯಿಂಗ್ ಟು ಅಪಿಯರ್ ನೋಡಿ ಇದ್ರಲ್ಲಿ ಮತ್ತೆ ಟೌನ್ ಪ್ಲಾನಿಂಗ್ ಅಥಾರಿಟಿ ಆಸಮ್ ಸರ್ವ್ಡ್ ನೋ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ 2015 ಮ್ಯಾಟರ್
Now it has been secret town planning authority. Now
changed to secret town planning authority.
It was done, it was Asan.
Asan, earlier it was Asan, now it is Arsigar Planning Authority. It has been already represented by the state only.
By the state.
You have filed the affidavit in the last question.
So you are going to appear for R2 also. And AGA submit that you would be also be appearing for respond number 2. Registry is directed to in the name of the AGA that appearing for R1 and R2. Vidya S has entered up for respond number 3. Delete the name of Linda K. Verma as that appearing for respond number 3. Yes, Mr. Nayak, ready?
Ready, Saminan. Allah, there are 2 sites are already constructed, my lord. My only site, the opinion has been given, it is a CS site. That's all, my lord, the point involved.
Correct beginning in the heading.
My humble request, my lord, I have purchased the site, my lord. Originally, it is Gizihalli Gram Panchayat, my lord. Then it was merged with Arsikere Town Municipality, my lord.
Yes.
Now they are saying that, my lord, my site is a CS site along with the other 2 sites, my lord, 36 and 32, my lord. And now other 2 site holders, they got the plan from the Gizihalli Gram Panchayat and put up construction. Now my site is considered that CA site. How can one site is going to declare as CA site, my lord? It is park area and they themselves permitted to put up construction. At the time of Gram Panchayat, my lord, there is no such park is identified.
Yes. What do you say?
Acha.
You have to speak in the mic for Mr. Nayak to hear.
Acha. There were 2 plans approved, my lords, for the layout plan, my lords, for the survey number 388 for 1.
Michael, speaker. Yes.
Let's in survey number 388 bar 1.
On madam. On madam. Sound ಬರ್ತಾ ಇಲ್ಲ.
ಚೆಕ್ ಮಾಡ್ತೀನಿ.
Yes. Just see if it is working. Mr. Nayak will pass over the matter. The mic is not working. You won't be able to hear anything.
Please, my lord. Please, my lord.
Nam mic work ಆಗ್ತಾ ಇದೆ, ಅಲ್ಲಿ work ಆಗ್ತಾ ಇದೆ. Pass over.
37, 38, adjourn, 39. Rashmi Patel.
ಆ mic work ಆಗ್ತಾ ಇದೆ ನೋಡಿ. ಅದು work. ಆಯ್ತು, ನಿಮ್ದೆ.
Application note 9 to 20, the government will directly
First statement of objection because my lord, petitioner is challenged constitutional.
634 acres of land. Whether it belongs to you or not, that is the question.
Mr. Nayak,
ನಾವು
Mr.
ವಾಪಸ್
Nayak,
ತಗೋಬೇಕಾಗಿದೆ. Please, Mela. Sorry,
ನಿಮ್ಮ ಅಡ್ವೈಸ್ ಎಲ್ಲ ಇಲ್ಲಿ ಎಲ್ಲರಿಗೂ ಕೇಳಿಸ್ತಾ ಇದೆ. Who appears for the response?
My lord, Sri H.S. Prashant, sir.
Mr. Prashant. Password. You have his phone number?
Please.
Mr. Prashant phone number ಇದೆಯಾ?
ಇಲ್ಲ, last time I tried to check it. Okay. ಇದರಲ್ಲಿ objections not. ಅಂದ್ರೆ ನಾನು ಮಧ್ಯಾಹ್ನ ಸ್ವಲ್ಪ they are not filed objections, so sorry.
None appear. Sri H.S. Prashant has entered appearance for respondent number 2 and 3. Delete the name of R. Subramania as that appearing for R2 and 3. None appears for respondent 2 and 3 today. If none were to appear for them on the next date of hearing, the matter would be taken up for consideration on the basis of submission to the counsel for the petitioner. We list on 14-3.
CH Prashant ಅಲ್ಲಿ HS ಅಂತ
SH Prashant. Like you would not know problem. Exactly. The registry has printed the name of the counsel for respondent number 2 and 3 wrongly. Directed to be corrected P. SH Prashant. Relist on 14-3.
Serial number 40.
You are appearing for.
I am for the petitioner.
Registry is directed to the name of Sri A. Sampath as that appearing for the petitioner. Mr. N.K. Ramesh, ready? Vijay?
Lord, I am ready. You didn't see him in the morning also. If I have it next week, I will.
If you are ready, then why next?
I am ready, Lord, but
You have his number.
yes, Lord.
Call him and say he's been summoned. Pass it.
Please.
41.
2:30.
12:30, we are already more or less with the list because nobody is here today.
Please.
41. Yes, Sampath.
Petitioners. It's the matter of the petitioner seeking, my lord, the resident of the layout.
CMC Nagra yaar. CMC Ram. Standing counsel. This is
Please, my lord, the petitioner is my lord, the practicing advocate. My lord, he's a resident of the layout at Ramnagara. Lord, his grievance is that, my lord, in his layout, annexure A, my lord, lordship may kindly take. Annexure page number 9. This is the layout plan, my lord, lordship may find. Page 9. The layout plan, my lord, in which in the middle, the green garden with park anta mentioned. Lord, his grievance is that, my lord, the official authorities has not developing this property and there are several encroachers and they have not protected this layout plan. Hence, my lord, he made a representation which was considered and they said, my lord, there is no encroachment and that will be developed.
Resident of this area.
This area, please. My
Site
site number 14, my lord, lordship find at the top.
next to the garden.
Please, my lord. So, my lord, he has made a several representation, which was considered, my lord, at one representation, lordship find it, page number 19, annexure G, my lord.
Yes.
In this, my lord, they considered and said the park measures, my lord, 16 to 110, and there is no encroachment. However, they assured that, my lord, they will develop this layout garden, my lord. After this, my lord, they have not done anything. Hence, I request, my lord, on this.
And who has to do this?
CMC.
That's
My lord,
number 1.
one and also, my lord, please. And also the town planning.
Despite service of notice on respond number 1, yavattam agide notice. Respond number 1.
November 2022.
ಇನ್ನು ಹಿಂದೆನೆ. Hmm.
5th August 2015.
5th August 2015. The city municipal council has not bothered to appoint a council. And they are not. Now, secretary, your secretary,
Under UD, my lord, urban development.
you know RDPR.
Urban development.
Then AGA is directed to bring the above to the notice of the principal secretary, urban development department. It is seen that in many cases, the city municipal councils are not being represented, leading to delay in the processing of the petitions pending before this court. Again, who will appear? Can you not take notice?
No, I'll instruct the department. Communicate to the commissioner, chief commissioner, and then any council is appearing, you'll appear in the next date of course.
Maybe around 30% of the cases are like this.
Usually communicate to the chief commissioner. Definitely will appoint the panel. Next date appearing.
The Principal Secretary, Urban Development Authority is also directed to cause the filing of an affidavit by himself or through concerned person, detailing out the names of the councils, standing councils appointed for all city municipal councils.
With respect to city municipal council, will be changing. Another commissioner comes, will be changing the council.
ಇವಾಗ ಯಾವ್ದು ಇದೆಯೋ ಯಾವ್ದು ಚೇಂಜ್ ಆಗುತ್ತೋ ಅವಾಗ ಇಮಿಡಿಯೇಟ್ಲಿ ಹೇಳ್ಬೇಕು ಅಷ್ಟೇ. Municipal councils in the state of Karnataka. Within this jurisdiction, with the Registrar General bifurcated by the benches at Dharwad and Kalburgi. ಇದು town municipal council ಇವರಿಗೆ ಬರುತ್ತಲ್ಲ. Similar action to be taken in respect of town municipal councils and Gram Panchayat.
Panchayat is the CEO.
Panchayat.
Panchayat will have a separate list of parameters. I'll give.
ಇದು ಯಾವಾಗ ಇಟ್ಕೊಳ್ಳೋಣ?
UDA and DMA will come. Municipal administration and duty for the CH and TMC. For the panchayats, Gram Panchayats, DO concerned.
Secretary, Urban Development Department and Director Municipal Administration. So when should we take up this matter? When will somebody get in?
Matter next week can be taken. By that time I'll take instructions from for this particular case.
Relist
Compliance, I'll instruct the.
on 2 weeks time is granted for compliance with the above directions. However, for the consideration of this matter, learned AGA is directed to secure instructions or request the Director Municipal Administration to appoint a council to appear in the matter. Released on 16th March.
Figure number 42 and 43 adjourned, 44.
The petitioners have filed application for allotment of sites.
PK Manjunath, Akshay. Akshay.
Statement of objection is not filed.
Not filed. Akshay was here. You are ready. Madam? Not ready.
My senior is on her lap.
She is ready.
Yeah, password. I'm praying for a password.
Password.
Okay. There
is another course. There are other password cases.
Already.
I pray for short accordance.
So counsel for the petitioner is present. Counsel for the petitioner and respond number 2 are present, none appears for respond number 3. Pre-list on 10th March.
Grateful, man.
45. The representative of that.
Petitioner.
What section?
What inspection report?
What inspection?
Earlier, my lord, there were directions from the Assam court regarding status of the thing as to whether there is violation or not, my lord. Connection R2, my lord. Page 6.
Affidavit.
Earlier, we had filed one report that there was some mistake. In the affidavit, they say, my lord, very.
You are the Commissioner, City Municipal Council, who doesn't know how to calculate the setbacks. Until it is brought to the notice by the petitioner during the process. Arguments. Then you correct your earlier affidavit. File an affidavit without even verifying.
Filed a fresh report.
Why should action not be taken against you? The only assumption that comes about is that you are colluding with the respondent.
No, madam.
Because you never have filed this. Realize that measurement given in the said affidavit, setback mentioned in the said affidavit, taking into consideration the existing building orientation and not taking into consideration depth and width of the site or the location. Does it change on the basis of a building orientation? If the setbacks change, even the explanation which you offered is not acceptable.
It seems that on that day, my lord, when the affidavit was filed, the case was called out, Commissioner was present, my lord. Immediately was directed to file the affidavit. My lord, I am not supporting Commissioner, my lord. But in a hurry, my lord, it was filed. Hurry, my lord.
You don't want something else to happen to you.
No, my lord. In a hurry, it was filed. Then, my lord, it was filed. Next day, they realized, my lord, then files a
orientation. ಅದಕ್ಕೆ ಏನು ಸಂಬಂಧ?
ಅಂದ್ರೆ ಇದು ಅದನ್ನ ಇಲ್ಲ ಕೋರ್ಟ್ ಹೊರಗಡೆ ಟೈಪ್ ಮಾಡಿಸ್ಕೊಂಡು ಇದು ಮಾಡಿ.
Actually, the setbacks as per the regulations are to be left as per the depth and width of the site and not taking into account the existing building. Existing building, you will determine setbacks. There is a deliberate attempt to mislead this court. The deliberate attempt to mislead this court.
Oh my God. ಇಲ್ಲ ಅದನ್ನ ಇದು ಕಮಿಷನರ್ ಪ್ರೆಸೆಂಟ್ ಇಡ್ಲಿಕ್ಕೆ ಅಂತ ಹೇಳಿ ಅರ್ಜೆಂಟ್ ಫೈಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಇಲ್ಲ ಹೊರಗೆ ಟೈಪ್ ಮಾಡಿಸಿ ಇದು ಮಾಡಿ ನಮ್ಗೆ ಗೊತ್ತಾದ ಕೂಡಲೇ ನಾವು ಅದಕ್ಕೆ ಕರೆಕ್ಷನ್ ಮಾಡಿ
An affidavit has been filed by the Commissioner, City Municipal Council. Puttur DK District. Stating that the earlier affidavit which had been filed was by mistake. Same is rectified by the present affidavit. He submits that it is stated in the affidavit that on the earlier occasion, in the urgency, there's a mistake which has been committed. ಅದಕ್ಕೊಂದು ಅಪಾಲಜಿನೂ ಇಲ್ಲ.
ಹೇಳಿದ್ದಾರೆ ಸರ್ ರೈಟ್ ಅಲ್ಲಿ.
And the same may be added. Accepting the such statement, the new affidavit is taken on record. More so since it is stated therein that now action has been initiated to remove the enforcement by applying the proper law. ಅವಾಗ ರಿಮೂವ್ ಆಯ್ತಾ ಇಲ್ವಾ?
ಆಗಲಿಲ್ಲ. 20% order as per the order.
As per the order, you are supposed to do. The petitioner doesn't need to come to court if you have done your work. When will you do it? ಅದನ್ನು ಹೇಳಿಲ್ಲ ಇಲ್ಲಿ. When will you do it?
3 months. Within 3 months.
3 months.
2 months.
And counsel for the respond number 2 submit that the enforcement should be removed within a period of 2 months from today. His submission is placed on record, released on 24th May. 25th May.
Lord, I am appealing for the petitioner. Lord, I request 1 week time to file the objections to the report submitted by the BBMP, my lord. Last occasion, my lord, I took time because of some
Who is appearing for respond number 3 now?
Respondent number 3, my lord, I provide one.
Who is appearing?
Nataraj is appearing.
ST Nataraj has entered appearance for respond number, delete Judicial Kumar as appearing for respond number 2. The counsel for the petitioner seeks for and is granted
To file the objections to the report submitted by the BBMP, my lord.
time.
10 days time.
10 days time to file objections to the report submitted by objections if any by 17th, relist on 21st.
Much over.
47, CP Kulkarni and corrected matter.
Sarita Kulkarni appearing for the respondent in writ petition, my lord. Takes pass over.
But the question involved is whether a doctor has to take a trade license under the Karnataka Municipal Corporation or not. That is the only question involved in my writ petition. In another writ petition, my lord, the subject matter is quite different. My lord,
But it pertains to the same subject matter, my lord. Obtaining a trade license by the just to run a private clinic.
No, whether my lord
in the connected matter, my lord, trade license has been issued and it has been renewed time to time also. They have issued a notice for the trade license has been issued. They have issued the notice to close the clinic, stating that it comes in residential area.
So
Now you are preparing for the BBMP in that.
Yes, my lord.
47 Shri A. Jagannath has entered appearance for respond number 1. Delete the name of M.N. Ramanjanay Gowda as that appearance for respond number 1. 47.1. Who is appearing in this? Sarita Kulkarni.
Sarita Kulkarni, my lord.
Sarita Kulkarni has entered appearance for respond number 1 and 2. Delete Ashwin Alagi, K.V. Batte Gowda
I'm appearing
as that appearing for R1 and R2. This Archana Murthy has entered appearance for respond number 3. Delete K. Vijay Kumar as that appearance. Again, is changes. Passing.
My lord, one submission, my lord. In the afternoon, I have other matters, quotal number 23, which are part-heard matters. They kindly be taken up on some other date.
Everybody is busy today, except us.
There are a couple of matters which are part-heard matters.
Relist on 6th March.
6th.
What is his objections on IA 2 of 23?
my lord, they have produced some document Their grievance is, my lord.
You are not served a copy, please, sir.
Sir, a copy is served.
47 only. The counsel for the respond number 1 confirms receipt of copy of IA2 of 2023. His office objection does not survive for consideration.
48.
Yes, my lord. Prepared for the petition. I've just recently come on record, my lord. The name as for Mr. Baswaraj Puja's name may be deleted. Suman.
Yes.
And I've also been informed that there was a spot inspection report filed, madam. I apologize for not coming physically. I've just injured myself yesterday. I may just be permitted to file my objections insofar as the spot inspection report is concerned. I've not been served a copy. I'll collect a copy from the council for the response.
Construction itself is an unauthorized construction without any sanction plan nor any permission from the Gram Panchayat.
But the inspection report has been served.
Inspection report has been filed.
Has been served on him.
No, he had only undertaken to file wakalat.
Please.
That
I was
Suman
not
had
officially on record that day, Marat. I would concede as far as that is. I was not officially on record. I undertook to file the NOC wakalat. I just filed the NOC wakalat recently.
Now that the report is there, you can collect it.
Please, I'll have it collected, Marat.
During the course of day to day.
Please, Marat. My colleague is there. I'll have it collected, Marat. Please.
That Suman has entered appearance for the petitioner. Delete the name of Baswaraj Pujar. Yes, as that appearance for the petitioner. Shri A. Jagannath has entered appearance for respond number 2 and 3. Delete the name of M.N. Ramajnai Gowda as that appearance for respond number 2 and 3. Shri A. Jagannath has filed a spot inspection. This has been taken on record. Shri Siddharth Suman submits that a copy has not been received, but he will collect the same from A. Jagannath during the course of the day. Objections, if any, to the said report by 10th March, relist on 14th March.
any date before the 9th or after the 13th.
After the 13th. Yeah, they will file objections by 10th, 14th is the date.
Please, grateful.
49.
Appearing for the petitioner in this matter, Your Lordship. I request for a short accommodation in this matter, Your Lordship. Need to seek instruction from the client.
Director, Port and Inland Water Transport, Mangalore.
We'll take notice.
ATA accepts notice for respond number 6. 1, 2, 3, 4, 5, 6. Council, pleadings are complete. Pleadings are complete. Counsel for the petitioner seeks for and is granted a week's time to get ready and address his arguments. Released on 7th March.
Much obliged, Your Lordship.
It is made clear that no further adjournment will be granted.
Yes, we Prakash.
Appear for petitioner, my lordship. I am filing an order copy this matter, my lordship. Kindly week's accommodation, my lordship.
Filing what?
Order copy application.
Now order copy. Yen order copy agbeku. Yav order copy agbeku, madam?
Trial court on the order copy application. Kindly week's accommodation.
Counsel for the petitioner seeks for and is granted a week's time to produce the order copy passed by the trial court. Released on 7th. If by then the copy is not filed, the petition will be liable to be dismissed. Yes.
51. Vikas Act.
Yes, my lord, I appear for the petitioner. This matter relates to the payment of demand for payment of road cutting charges by the first respondent Gram Panchayat, my lord. The dispute is with respect to the road which is being.
Yes.
My lord, I just mentioned that I'm requesting for a short accommodation in this matter, my lord. What has happened?
Adjournment pass over.
I just request for a short accommodation, my lord. Senior counsel is engaged in this matter. He appeared on the previous occasion.
So accommodation is in terms of an adjournment or a passover? Adjournment. You are ready?
Any early? My lord, Gram Panchayat has not yet filed its objections. The dispute is relating to whether the road belongs to the Gram Panchayat or the government, my lord.
They don't want to file it.
We have already been filed it.
You have no objections.
Within a week's time, we'll fill out.
Because we have already paid money to the government for carrying out the work. And the power under which they are claiming they are imposing the road cutting charges, my lord, that came into effect through an amendment, which was subsequent to carrying out the work, my lord.
Subsequent.
The amendment came subsequent to carrying out the work.
But you have cut the road.
That we did with the permission of the state government. They have collected fees. Annexed A.
State government is collected.
State government has. So the dispute is whether the road belongs to the Gram Panchayat or the government.
Then you have to go, if the state government has already collected the,
If it is-
you collected from the state government.
If it is PWD, it is the first statement. Road belongs.
It's a major artery connecting the IC.
From what the Learned Council says is between both of you. You have already collected from you. You are not giving them.
You have to clarify whether it belongs to Panchayat or the PWD road or in.
But you have collected the money.
Yeah, if it is collected.
Annexed A is the.
If you want to give it to the panchayat, you can give it. You want to keep it, you can keep it.
It's a major road, my lord. It connects the IT city.
The essential dispute appears to be between both of you.
I'll get instructions and my.
And counsel for the petitioner submit that the road which is cut, being a major arterial road, necessary road cutting fees has already been collected by the state government, which has been paid by the as paid by the petitioner. It is thereafter that the Gram Panchayat also seeks to levy similar road cutting charges, though of course subsequent to the amendment to the.
Although the amendments came subsequent to the carrying out of the work.
Amendment to what?
Amendment to the Act, my lord, Panchayat Raj Act, my lord.
Panchayat Raj Act. Faced with the above situation, Learned Counsel for Learned AGA as also counsel for respond number 1 and 2 submit that they would seek instructions as to whether the Gram Panchayat can receive the money from the state government if entitled or not. If entitled. Relist on 10th March.
Grateful, man.
If they're entitled, give them the money. You can't levy it twice. You know?
Yes, yes.
Petitioner matter, right? 2 weeks accommodation. The petitioner has informed that they are issuing a no objection wakalat to the matter. They have not received a file in that regard, Your Lordship. 2 weeks time may be granted.
So you are appearing for Ms. Bina or you are going to appear?
They have informed us that they are getting a no objection wakalat from them. We will hand it over to them.
BBMP not given objections for the BBMP.
We are again respond number 1 and 2.
Office copy.
Petition copy na kote. Counsel for respond number 1 and 2 submit that he has not received copies of the petition. In the next year, counsel for petitioner is directed to serve the same by end of day tomorrow.
Please.
Relist on 20th March.
Much of it.
Appearing for response, please kindly provide 2 weeks time now.
We are appearing for Mr. Ramchandran or Amit Deshpande?
Amit Deshpande.
Petitioner yaar
Satish Kumar.
Nagarajappa associate.
A. Nagarajappa has entered appearance for the petitioner Dilip Bindu M and T. M. Venkat Reddy. Amit Deshpande has entered appearance for R1 and R2. Dilip Dr. R. Ramchandran has entered appearance for R1 and R2. None appears for the petitioner, though counsel for R1 and R2 is present. If none were to appear for the petitioner on the next date of the petition will be allowed to this 16.
54. GS Venkata Subbarao.
No, the Taluk Panchayat.
The private respondent.
Taluk Panchayat served no representation.
Yes, Somay.
Yes, Somaji.
Yaak appear ಆಗಿಲ್ಲ ಎಲ್ಲಿ ಸೊಮ್ಮ? Somaji.
The state Tala Panchayat.
For R2, there's the shown is then. For this also.
R3 ಯಾಕೆ ಹಾಕಿಲ್ಲ?
R2.
BJ Somyaji has entered appearance for R2 and R4. He is also directed to take notice for respond number 3. Registry is directed to
For secretary video. Common place change. Secretary.
Who 4 years already appeared. R2 to
R2 and 4 are there.
3 and 4.
PJs only.
You one no.
5 is a private.
Five is a private.
RS Ravi Senior Counsel.
Hello. Not in that.
RS Ravi. You are ready.
I'm ready. Short matter.
You'll pass over. Just get me so many. You take it up.
Tomorrow.
You are the one. ನೀವು busy na?
ಇಲ್ಲ 23 ನಲ್ಲಿ ಒಂದು ಬ್ಯಾಚ್ ಮ್ಯಾಟರ್ಸ್ ತಗೊಂತೀವಿ ಅಂತ ಹೇಳಿದಾರೆ ಹಾಗಾಗಿ
ಏನು ಕೆಲಸ ಇಲ್ಲ ಯಾರು ಒಬ್ರು ಇಲ್ಲ ಅಲ್ಲಿ
I'll wait.
another 15 matters that's it.
Fresh roster first day, so maybe. I'll wait.
Pass.
55 Narasimhamurthy ke
Respond.
Lord, 55 appear for respond number 10, my lord.
Yes.
I request for a short adjournment, my lord.
For what?
My lord, my senior is unwell today, my lord. That is the reason.
Start point is there. Petitioner contention is that they are not given the opportunity before the authority.
Narasimhamurthy. Very not heard ಅಂತ ಅಷ್ಟೇನಾ?
The grounds ಅಲ್ಲೇ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳಿದೆ ನಮ್ಗೆ ಆಪರ್ಚುನಿಟಿ ಕೊಡ್ಲಿಲ್ಲ ಮ್ಯಾಟರ್ ಅಡ್ವಾನ್ಸ್ ಮಾಡ್ಕೊಂಡು ಇಮಿಡಿಯೇಟ್ಲಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ರು ಅಂತ ಆಪರ್ಚುನಿಟಿ ಕೊಟ್ಟು 1 second ಬೇಕಾದ್ರೆ
Pass over. You can't pass orders in the, even in their favor. Pass over. In 1 PM, considered offense for petitioner, the big doctor is no touch. Secretary Department of Urban Development served. AG accept notice for respond number 1. Mr. Shivramu, counsel for the petitioner is directed to serve a copy of the petition along with connections on respondent. What does this matter, Ms. Mohan?
No, very not fishing license is granted in my favor.
Fishing license.
Yes, in fact, now it has been further renewed, not for a further period, not of about 5 years. Meanwhile, not the panchayat not issues the notification calling for applications from prospective persons for tourism. For tourism, not fishing activities, not it becomes difficult for us to carry on tourism if they carry on tourism in there, but because fishing nets etc. will be there.
Tourism, sense, are there going to be boats?
Boating, etc. Which not the South Court is pleased to grant an interim order saying that not cannot be done. And because I have fishing rights given in respect of that particular.
Really, this is in a lake or?
But this is a river, Kaveri River. In that radius plot, if they want to give it, because in fact earlier not even the petitioner had sought. Then they said, no, you can't do it. That we have not permitted you to do it. It is 2011. There was a writ petition also before the Honorable Court. Ultimately, not 2016. What the panchayat does is, panchayat not says I call for applications. That plot they cannot not call for such application because not river and other not everything comes under not the comment.
I think lake or river.
Like when the
Lake as the fishing policy, but again not in the fisheries department. Panchayat may not have that jurisdiction.
only statutory permissions can be taken. When as per the annexure, the Tourist Department has given endorsement that they are not taking any permission from them. The municipality has not sought any permission from the.
The executive officer, Taluk Panchayat, Chikbadapur.
Okay, sir.
President, Dodmaralli, Gram Panchayat.
I will accept notice, sir.
For Yarigi.
Jilla Panchayat Taluk.
R1, 2, 3, 4.
Yes, sir.
Nalakku ko accept matla. So accept notice for respond number 1, 2, 3 and 4.
MS Devraj.
None appears for the petitioner. Counsel for the petitioner is directed to furnish a copy of the petition along with annexures in
MS Devraj.
triplicate.
Yes, ma'am.
More copy back
Okay.
in triplicate to the council. Released on 20th March.
58. Sridhar AG.
Please 2 weeks time. Okay.
Taluk Panchayat represented by PDO Mysore. DJ Somyaji, who has entered appeals for respond number 1 and 3, is also directed to accept notice for respond number 2. Counsel for the petitioner seeks bond is granted 10 days time to get ready and address, weeks time to get ready and address his arguments. Released on 13th March. It is made clear that no further adjournment will be granted.
59. Maybe Nishant and corrected matter.
I appear for petition in the first matter.
The AGA accepts notice for respond number 1. R2 DC election officer.
This matter has become infectious.
Because no confidence motion meeting, but already.
You accept ಮಾಡ್ತೀರಲ್ಲ? R1, R2, R3. 59.1 ನಲ್ಲಿ ಬೈಂದೂರ್ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಯಾರು?
ಪಂಚಾಯತ್ ಎಲೆಕ್ಟೆಡ್
ಬೈಂದೂರ್.
I'll accept one.
Notice for in full list ಕೊಡಿ.
Only 5 district one.
And counsel for the petitioner submit that the above petition has been rendered infructuous.
The first matter. Second matter.
The first matter, 59. And counsel for the submit that the above petition has been rendered infructuous. Accepting his submission, the petition is dismissed as infructuous. 59.1.
Then notice ಹೋಗ್ಬೇಕಾಗುತ್ತೆ. First matter
Petitioner.
advocate. ಅದು infructuous ಆಗಿರ್ಬೇಕು.
It was also been infructuous.
Same.
ಬಂಡಾರಿ ಅವರಲ್ಲಿ.
ಬಂಡಾರಿ ಅವ್ರ ಹತ್ರ.
ಅವರು 59.1. The counsel who had appeared for the petitioner has now been appointed the judge of this court. His notice normally would have ought to have gone to the petitioner. But considering that the dispute itself no longer survives and the petition has been rendered infructuous, the formality of issuing notice to the petitioner is dispensed with. The petition stands dismissed as infructuous.
Number 60. Sayyid Zamir Pasha.
On behalf of BSI.
The Zamir Pasha.
So notice may be issued for the petitioner, my lord, as she is 72 years aged in the 2016. I think she will be alive.
Don't make such kind of a submission.
Notice may be issued.
Unique notice. The counsel already on record.
So, my lord, my colleague informed me that had to inform that the petitioner advocate is also no more. Petitioner advocate is also no more.
Petitioner advocate is no more. There, but counsel for respond number 3 submits. Sure,
my colleague informed me.
Submit that the counsel for the petitioner is no more. Registry is directed to issue court notice to respond to the petitioner, returnable by 10th April. The counsel for the petitioner is now designated senior counsel. And issue notice to the petitioner. There is no representation on behalf of the petitioner. Issue notice to the petitioner returnable by 10th April.
Asala Kumar. Asala Kumar along with PDF.
Nothing else.
62. Arji Halesha.
62. Pass over.
Ramesh Chandra.
I appear for the petitioner, my lord. I seek short accommodation. Office shift to file ella sigta illa sir.
My lordships, I may be permitted to make a submission, my
Yes.
lordships, and for the impleading applicants in this matter. my
For the
lordships.
impleading up.
That application was rejected long ago.
I have withdrawn the application.
You have withdrawn.
Yes, my lordship.
So your name can be deleted.
Yes, please, my lordship. I filed a
Application was rejected, my lord.
What's your name?
Shloka, my lordship.
So and so submits that the IA number 1 of 16 has already been rejected, hence her name, hence the name of Shri P.B. Ajit and Tontagare RK may be deleted as that appearing for impeding respond number 3 and 4. As submission is accepted, registry is directly delete the name of so and so as that appearing for R3 and 4. None appears for KR Ramesh for R1 and R2, A Nagarajappa for R1.
R1 ಅಥಾರಿಟೀಸ್ ಮೇಲೆ ಅದೇನಾಗಿದೆ ನಮ್ಗೆ ಪ್ಲಾನ್ ಆಗಿತ್ತು. ಪ್ಲಾನ್ ಆಗಿದ್ರು ಅವರು ಚೇಂಜ್ ಆಯ್ತು ಪಂಚಾಯತ್ ರಾಜ್ಗೆ. ಅವರು ಪ್ಲಾನ್ ಇಲ್ಲ ಅಂತ ನೋಟಿಸ್ ಕೊಟ್ರು. ಪ್ಲಾನ್ ಆಗಿದ್ರೆ ಅದು ಚೇಂಜ್ ಆಗಿದ್ರು.
ಅಪಿಯರ್ ಆಗ್ತಾ ಇದೆ R1 ರಮೇಶ ನಾಗರಾಜಪ್ಪನ.
ನಾಗರಾಜಪ್ಪ.
R2 ಗೆ
ಗೊತ್ತಿಲ್ಲ ಸರ್.
R2
ಈಗೆಲ್ಲ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ. ಈಗ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಗ್ರಾಂಟೆಡ್ ಸ್ಟೇ. ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಇಸ್ ಇನ್ ಅಕಾರ್ಡೆನ್ಸ್ ವಿತ್ ಲಾ ಪ್ಲಾನ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ. ಒಂದ್ಸಲ ಈಗ ಅದನ್ನು ವಿಚಾರ ಮಾಡ್ತೀನಿ ಸರ್.
CMC ಹೆಬ್ಬಗೋಡಿ.
CMC
ಹೆಬ್ಬಗೋಡಿ.
notice ಆಗಿದೆ.
You appear for R2 also.
A Nagarajappa R1.
R2 ಗೆ ಯಾರು?
R2 ಯಾರು?
R2 ಯಾರಮ್ಮ?
KR Ramesh.
KR Ramesh R1 and R2 ಎರಡು ಇದೆ. R2 ಯಾರು?
R2 CMC ಹೆಬ್ಬಗೋಡಿ.
CMC ಹೆಬ್ಬಗೋಡಿಗೆ ಅಪಿಯರ್ ಆಗ್ತೀರಾ ನೀವು?
ಇಲ್ಲ, ನಾವು we are not signing.
CMC ಹೆಬ್ಬಗೋಡಿ.
R1 CMC ಹೆಬ್ಬಗೋಡಿ ರೀ.
We'll take notice.
A Nagarajappa was entered appears for R1 also accept notice for respond number 2. Delete the name of Shri KR Ramesh as that appearing for R1 and R2. Shri Ramesh Chandra, the counsel for the petitioner seeks for and is granted a week's time to get ready and address his arguments. Released on 6th March.
I represent the respondent, my lord. In this matter, my lord, I kindly grant 2 weeks time, my lord. I will file the objections, my lord, because the executive officer has transferred newly assumed charge. He was not aware the facts, my lord.
Mr. Nityanand,
Kindly grant 2 weeks time, my lord.
what are the matters gained?
Lord, it is RM narrative will appear.
R1 ಯಾರು ನೋಡಿ, R2 ಯಾರು ನೋಡಿ. There is no representation.
Panchayat, I am appearing, my lord.
Alak Panchayat mission M narrative will appear.
ಹೌದಾಯ್ತು. R1 and R2 ಅಪಿಯರ್ ಆಗ್ಬೇಕು.
I will.
Served ಆದ್ಮೇಲೆ if you don't appoint anybody.
We'll take notice.
And AGI accepts notice for respond number 1 and 2. None appears for the petitioner. Learned counsel for respond number 3 and 4. Seeks for 10 days time to obtain instruction. If none were to appear for the petitioner on next date of hearing, petitioner private non-prosecution will be on 16th March.
Muda and Mysore corporations. Muda
ಎಲ್ಲಿದೆ?
ಇಲ್ಲ, ಮೂಡ ಇಲ್ಲ, ಇದು ಕೋಲಾರ.
ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಕೋಲಾರ.
65.
ಇದು ಅಪಿಯರೆನ್ಸ್ ಏನಾದ್ರು ಮಾಡ್ಬೇಕು.
I represent the respondent.
ನೀವು 3 and 4 ಆಯ್ತು.
ಅಲ್ಲ, ಇನ್ನೊಂದು ಮ್ಯಾಟರ್, ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್
1 and 2 ನೋಡಿ.
65 man.
These are the places where there's so much of time
it will consume.
Gets wasted.
No.
Some system has to be put in place for this. Service ಆದ್ಮೇಲೆ you have to file wakara. ಏನಾಗುತ್ತೆ service ಆದ್ಮೇಲೆ?
No, what will happen is after the notice, now the artist will be implemented. In that, of course, this things happens.
Service has been effected on the Secretary Panchayat Raj. What happened to that notice?
I'll take.
It's been effected on the Deputy Commissioner Kolar. With the private party, we always say service held sufficient. ನಿಮಗೂ ಹಂಗೆ ಮಾಡ್ಬೇಕು.
ಇಲ್ಲ ಅದು ensure
Lordship, I'm appealing petitioner in this case. Your Lordship,
Ready?
ready for the.
Yes, Mr. Nayan Reddy, ready?
In this matter, my lord, the petitioner has challenged the order passed by review, order passed by the.
Mr. Reddy, are you ready to address arguments?
Yes, my lord.
Reddy andre you ready antalla ready na anta
ready sir.
Yes.
Lordship, petitioner is the rightful owner in the possession and enjoyment.
You have to speak in the mic, please. Switch it on.
Lordship, petitioner is the rightful owner and in possession and enjoyment of the house of your Lordship, and there is a dwelling house also. Site bearing number 42. It is situated in the Nukkahalli in jurisdiction of Totadahalli Gram Panchayat Kola, which bears measurement of 90 feet per 33 feet, Your Lordship.
Yes.
Your Lordship, the Panchayat assists the scheduled property for the tax and for the collection of the same from the petitioner. And the Annexure A, Annexure B and Annexure C are the assessment register maintained by the Gram Panchayat and the tax extract form number 9 and the two receipts of the tax with Your Lordship. Lordship, R4 got Khata in his name illegally and agreed by the same by the illegal registration in the name of R4. The petitioner preferred an appeal before the executive officer, Taluk Panchayat, Kola, which is respondent number 2, Your Lordship. And he didn't entertain this appeal as it was presented beyond the period of 30 days. Lordship, the petitioner approached respondent 1 and he got an endorsement dated 26/6/2012 issued by the executive officer, and the appeal was allowed, Your Lordship, and the khata which was done in the favor of respondent 4 was set aside. That is by Annexure E, Your Lordship.
Yes.
Lordship, then the respondent 4 filed a review application as mentioning section 114 of CPC read with section 151 of CPC, and respondent 1 allowed the appeal erroneously, Your Lordship, which was already decided in favor of R. The review petition is in Annexure F, Your Lordship, and the order sheet of the same is mentioned in Annexure G, and the written argument which was filed by us, that is the petitioner, is in Annexure H, Your Lordship. And allowing the review petition, that is mentioned in Annexure J, it was declared against our Your Lordship, and it was dated 23/8/2016, which is mentioned in Annexure J. Lordship, according to the petitioner, this review application itself is not maintainable because there is no jurisdiction on the part of respondent 1 under section 114 of CPC, Lordship. Because in this particular case, Your Lordship, the provisions which is applicable here is in accordance with the Karnataka Gram Panchayat and Gram Swaraj and Panchayat Act 1993. But here the entertaining of the review application itself is erroneous on the part of respondent 1, Your Lordship. And Your Lordship, when this was entertained, the Adhyaksha was Ratmurti Nanji Gowda, who allowed this application, and it was reserved for the orders, which was on 28/10/2014.
Mr. Reddy, what is the power of review vested with you?
There is no power, my lord.
Then how would you review? Whether it is or not?
Lord, kindly see Annexure D, my lord. First of all, Annexure D, the appeal preferred by the under section 269, Annexure D, my lord, page 18.
Yes.
Instead of deciding the appeal under section 269, delay ಇದೆ ಅಂತ ಹೇಳಿ delay idelaಗಿದೆ ಅಂತ ರಿಜೆಕ್ಟ್ ಮಾಡಿದೆ. This itself is wrong. He has to dispose of the appeal under section 269. He has got power. Even delay idru, he has to condemn whatever he has seek for an application. The endorsement itself is issued authority is wrong. Against this order, they have preferred an appeal before the Adhyaksha of the Jilla Panchayat and the section 269. 269 is now no power to Adhyaksha. It is power vested with the.
That is not what is under challenge before us. What is under challenge is the review petition.
Review, sir.
The power for review under 115.
Power illa, sir. There is no power.
So we'll have to say if somebody is aggrieved by it, they can go and appeal on the order. But review you can't do on this.
Yes, ma'am.
Petitioner is before this.
The original order itself, my lord, passing the executive officer without considering the appeal under section 269 itself is wrong. my lord.
Remedy is an appeal, Mr. Reddy, not.
Yes, sir. 269 ಇದೆ ಅದು ಮಾಡಬೇಕಾಗಿತ್ತು ಮಾಡಿಲ್ಲ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
We'll reserve that liberty.
Yes, well. It may be remanded to the executive officer to pass appropriate order in accordance with law.
We'll set aside the order of review. If anybody is aggrieved, that's all.
Please, ma'am.
Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the respond number 1 has reviewed its own order dated 3/6/2014 on an application which had been filed by respond number 4 under section 114 read with section 151 of the Code of Civil Procedure. The contention of the counsel for the petitioner is that there is no such review powers vested with the first respondent Addiksha, let alone under section 114 read with section 151 of the Civil Procedure. Respond number 1 to 3, counsel for respond number 1 to 3 on inquiry is unable to show any particular power of review vested with respond number 1, even otherwise than under section 114 read with section 151 of the Code of Civil Procedure. None has entered appearance for respond number 4. In view of the above, when there is no such power of review which can be exercised by respond number 1, the petition would be required to be allowed. However, liberty needs to be reserved to respond number 4 to challenge the order at Annexure E dated 3/6/2014 if permissible under law. As I pass the following order. A certiorari is issued. The order dated 23/8/2016 passed by respond number 1 in writ application number 12 of 2014 at Annexure J is squashed. Just one investment. Counsel for respond number 4 is no more. Notice will have to go. You can't pass this order. It is informed that the counsel for respond number 4 is no more. Hence issue notice to respond number 4, returnable by 10th April. Issue court notice.
Number 66. Prabhakar Rao.
Respond.
Yes. Mr. Prabhakar Rao. Ready now?
I'm ready.
Pass on.
7. S.V. Prakash.
Prakash,
My lord, I appeal for petitioner.
ready?
My lord, I am ready. A.V. Gangadharappa, my lord, is opposing me.
ಅವ್ರು ಇವಾಗ ಸದ್ಯಕ್ಕಿಲ್ಲ ಅವ್ರು ಫೋನ್ ಮಾಡ್ಬಿಡಿ ವಿಲ್ ಪಾಸ್ ಓವರ್ ದ ಮ್ಯಾಟರ್. ಪಾಸ್ ಓವರ್.
Prashant Rao. 14%.
ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಿತ್ತು.
The matter was originally allotted to, the matter is allotted, Shri sir. He is no more, BBMP needs time for 2 weeks to make alternative arrangement.
Petition is
Sorry, ಏನ್
Srinidhi, earlier Srinidhi was appearing.
ಪವನ್ ನೀವು ಅಪೇರ್ ಆಗ್ತಿದ್ರು.
I am appointed as nodal officer for BBMP membership. So every note.
ನೀವು ಇಲ್ಲೇ ಕೂತ್ಕೊಂಡಿರ್ಬೇಕು ನಮ್ಮ ಕೈ.
Almost, I'm here on.
ಇಲ್ಲಿಂದ ಎಲ್ಲೂ ಹೋಗಂಗಿಲ್ಲ.
Yes, sir. For 2 weeks time we need to make alternative arrangement.
R3 ಯಾರು?
R3 urban development is not a nomenclature. Actually, we appear. The commissioner, the director of urban land transport.
AG accepts notice for respond number 3. counsel, once Srinidhi V had entered appeals for respondent number 2 and delete the name of Shri Pawan Kumar as the appeal for respondent number 2. Counsel for respondent number 2 being no more, the nodal officer requests for 2 weeks' time to appoint a new counsel for respondent number 2. Since the petitioner is a party in person, issue court notice to the petitioner informing the next date of hearing as 10th April.
Date given by.
Date given matter.
Oh, that's okay.
And earlier, Prashant. So Prashant Rao. Regularly appears.
Last
That
time.
Basungudi matters, no?
Yes, footpath.
Path,
Earlier,
temple.
Yes, sir.
He appears regularly.
Last date also he did not. Last date also he did
So he does not know. 10th, notice 10th.
For complaint serial number 69.
For petitioner.
Yes.
Millards, I appear for the petitioner, Millards. Millards, BDA has not complied with the order, Millards.
Will not come. Pastor, let Mr. Unikrishnan come.
Please, Millards.
Mr. Shivramu, ನೀವೆಲ್ಲಿ ಮಿಸ್ಸಿಂಗ್ ಇಷ್ಟೊಂದು ಮಾಡಿ ಇಟ್ಕೊಂಡು ನೀವು ಬರೋದೇ ಇಲ್ಲ ಅಂತೀರ.
What has happened with the files are also mixed, my lord. I wanted to take time for one day, my lord. I will get Xerox not day after tomorrow.
ಯಾವುದು?
Serial number 60, my lord. Sorry, 56, my lord.
56.
Yes, sir. So day after tomorrow, I will ready, my lord. An objection is there. Xerox one model.
Manmohan.
Manmohan illa idru helidina avage. I have told him just now he was here. I told him. They have to
56.
Next day, my lord.
S.C. Shivramu seeks for and is granted.
One day. Next day, my lord.
Released on
Short matter.
2nd March.
Second, before that one,
First Wednesday will take CS matter. All LB matters will be Monday, Tuesday, Thursday, Friday. CS matters on Wednesday.
Or else will not pass it over, my lord. I will.
That is best.
Tell him.
Pass over.
Another one matter.
We have Telegram ನೀವು ಸಬ್ಸ್ಕ್ರೈಬ್ ಮಾಡಿದೀರಾ? Telegram ಚಾನಲ್ ಸಬ್ಸ್ಕ್ರೈಬ್ ಮಾಡಿದೀರಾ?
ಮಾಡಿದೆ.
ಅದರಲ್ಲಿ ನಿನ್ನೆ 2 ಲಿಸ್ಟ್ ಹಾಕಿದೆ. ನಿಮ್ದು ಬಹಳ ಇದಾವೆ. ಕಂಪ್ಲೈನ್ಸಸ್ ಎಲ್ಲ ಕಂಪ್ಲೈನ್ಸ್ ಮಾಡಿ ಇಲ್ಲಾದ್ರೆ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್. 3 ವಾರ ಟೈಮ್ ಇದೆ ನಿಮ್ಗೆ ಮಾಡಕ್ಕೆ.
Serial number 60 ಒಂದಿದೆ. ಅದರಲ್ಲಿ ಅದು
60 I believe the petitioner counsel has expired. So we have issued notice.
Matter is already request to be allowed, your lordship.
But petitioner counsel has expired. ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗತ್ತೆ?
Notice ಮಾಡಿ.
Allow ಮಾಡಕ್ಕೂ ಆಗಲ್ಲ.
Notice ಮಾಡಿ. Yes. Notice has to go. Yes.
We can only dismiss. We cannot allow whatever they want to say, we'll have to hear.
Yes. Sorry, my lord.
ಇನ್ನ ಇದಾವೆ ನಿಮ್ದು.
ಇಲ್ಲ ಒಂದಿತ್ತು ಅದು
25 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. 25ರಲ್ಲಿ ಇದೆ.
25ರಲ್ಲಿ ನಾನಿಲ್ಲ ಸರ್.
ಇಲ್ವಾ ನೀವು?
ಇಲ್ಲ ನಾನಿಲ್ಲ 25ರಲ್ಲಿ ಇಲ್ಲ. 4ರಲ್ಲಿ ಇಲ್ಲ.
25 you are no longer appearing for R7.
4ರಲ್ಲಿ ಇಲ್ಲ. More better.
First and second sheet.
Bill number 20, served the copy. Bill number 20, served the copy.
Bill number 20. Counsel for the petitioner has served the copy of the petition along with annexes and counsel for the respondents. Counsel for the respondents seek for and are granted 10 days time to go through the same and make their submissions released on 13th March.
28, my lords. I'm sorry, the first round I was not here. I tried to quote out down, my lord. Because 2:30 I got another matter. Next week.
Don't have any matter, Mr. Gunjan. Finish the entire.
Second court on matter.
Then ಎಲ್ಲರೂ ಬೇರೆ ಕೊಟ್ಟು
ನಾಡಿದ್ದು ಮಾಡ್ತೀವಿ. I'm ready. 28.
At the request of counsel for the petitioner, released on second March.
Macho.
You will put 56, my lord. You will also directed take notice, my lord. I will serve copy today. 57, my lord.
57.
That I am ready, my lord. I will serve copy.
So much.
Day after tomorrow.
Now the date.
20th March.
20th March. Or instructions.
ಕಾಪಿ ತಗೊಂಡು
Instructions ಬರ್ಬೇಕಲ್ಲ. ಇದ್ರಲ್ಲಿ ಬಂದ್ರೆ we'll be very happy.
ಆಯ್ತು.
ಎರಡು ಪೇಜ್ ಇಲ್ಲ.
ಚಾರ್ಟ್ ಮಾಡಿ. ದೇವ್ರೆ. ದೇವರಾಜ್. ಎಕ್ಸ್ಟ್ರಾ ಕಾಪಿ ಇದೆ.
ಏನಾದ್ರು ಪೇಪರ್ ಕೆಳಗಡೆ ಬಿದ್ದಿದ್ಯಾ ನೋಡಿ.
56.
ಇಲ್ವಾ?
56.
ಎಲ್ಲೋ ಇಲ್ಲ.
56 ಟೈಮ್
ಬರ್ದೇ ಹೋಗಿದೆ. ಅದೇನದು ಅದು ಹೊಸ ಕೊಟ್ಟೆ.
ವಾಟ್ ಐ ಸೇ ಮೇಡಮ್ ನಾನು ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀನಿ ಟೈಮ್ ತಗೋತೀನಿ ಅಂತ ಫೋನ್ಗೆ 2ನೇ ತಾರೀಕು ಹಾಕ್ಬಿಡಿ. ಮಾರ್ಕ್ ಮಾಡಿ ಅದೆಲ್ಲ 2 ನಾಳೆ ಬುಧವಾರ ಇಲ್ಲ ಅಂದ್ರಲ್ಲ ಗುರುವಾರ ಥರ್ಸ್ಡೇ. ಸೆಕೆಂಡ್
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 44 ಏನಾಗಿದೆ? 44.
ಅದು 52.
20th March. Okay.
ತಗೊಳ್ಳಿ ಹೇಳಿ ಮೇಡಮ್. ಏನ್ ಮಾಡ್ತೀವಿ ನಾವು ಕೊಟ್ಕೊಡ್ತೀವಿ ಕೆಲಸ 23 ಅಲ್ಲ.
ತುಂಬಾ ನೀರು ಇದ್ಬಿಟ್ಟಿದ್ರಿ. ಇಲ್ಲ ಐತಿ ಈ ಕಡೆ ಇಟ್ಟಿದೀನಿ. ಬೇಕಾ ಕೊಡ್ಲಾ? ತುಂಬಾ ನೀರಿತ್ತು ಅಂತ ಈ ಕಡೆಗೆ ಇಟ್ರು. ಆಮೇಲೆ ಮುಟ್ಟಿದ್ರೆ ಅಸಹ್ಯವಾಗಿದೆಯಂತೆ ಅದು ಹೇಳಿದ್ರು. ಅದೇನೋ ಅಂಟಂಟ ನೀವು ಮುಟ್ಟಿ
ಈಗ ಅದನ್ನೆಲ್ಲ ಏನ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ತೊಳೆದು ಬರಾಕ್ಬೇಕು.
ಹಿಂಗಂದ್ರು ನೋಡಿ. ಹಿಂಗಂದ್ರು ನಂಗೆ ತೋರ್ಸ್ಬಿಟ್ಟು ತಳ್ಳಿದ್ರು.
ಫೈಲ್ ಸಿಕ್ಕಿಲ್ಲ ನನಗೆ. ಫೈಲ್ ಸಿಕ್ಕಿದ್ರೆ
ಫಸ್ಟಿಗೆ ಮಾಡೋಣ.
ಅಲ್ಲ ಫಸ್ಟ್ಗೆ ಅವರು ಬೇರೆ ಮ್ಯಾಟರ್ಗಳಂತೆ. ಫಸ್ಟ್ಗೆ ಕೋಆಪರೇಟಿವ್ ಮ್ಯಾಟರ್. ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ಬೇಡಿ. ತಗೊಂಡಿಲ್ಲ. ಎಷ್ಟು ತಮಾಷೆ ಮಾಡಿದೆ ಮೇಡಮ್. ನಮ್ದೇನೆ ಅವ್ರಿಗೆ ಅನಾನುಕೂಲ ಅಂತೆ.
ಹೇಳಿದ್ದವಾಗ್ಲೇ
56 ಮೇಡಮ್. ಅದೇ ಮೇಡಮ್ ನಮಗೂ ಇರೋದು ಇಲ್ಲ. 56ಗೆ ಡೇಟ್ ಚೇಂಜ್ ಆಗ್ಬೇಕಾಗಿರೋದು.
57ಗೆ ಸೇಮ್
7ಗೆ ಕೊಡಿ ಮೇಡಮ್. ಅವ್ರಿಗೆ ತೊಂದ್ರೆ ಅಂತೆ ಅದಕ್ಕೋಸ್ಕರ. ಇಲ್ಲ ಬೇರೆ ಆಗ್ಬೋದು ಮೇಡಮ್. ಎಸ್ ಮೇಡಮ್. ಎಸ್ ಮೇಡಮ್.
55 ಪಾಸ್ವರ್ಡ್ ಇದೆಯಲ್ಲ
ಮೇಡಮ್. ನಿಜಾಂಜಿ ಕೊಟ್ಟು ಕಳಿಸ್ತೀನಿ ಕಾಪಿನ. ಆಯ್ತು ಅದು ಅರ್ಜನ್ ಆಯ್ತು. ಅದು ಅರ್ಜನ್ ಆಯ್ತು 2 7ಗೆ. ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಬರ್ತೇನೆ.
ಅಂದ್ರೆ ಡಿಮ್ಯಾಂಡ್ ಮುಂದೆ ಇರಲಿಲ್ಲ ಜನರಲ್ ಆಗಿ ಎಲ್ಲಾದ್ರೂ ನಿಮ್ಗೆ ಯಾರು ಗೊತ್ತೋ ನಮ್ಗೆ ಹಾಕ್ಬೇಕು ಅಂತ ಏನಿಲ್ಲ ತಮ್ಮನ್ನ ಅದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಒಂದಿನ ನೋಟಿಫಿಕೇಶನ್ ಆಗಿದೆ ಇವತ್ತು ಅವ್ರು ಅಲ್ಲಿಂದ ಏನ್ ಸೌಂಡೇ ಬರ್ಲಿಲ್ಲ ಅಲ್ಲಿ ನೋಡಿ ಸರ್ ಕೋರ್ಟಲ್ಲಿ 18 ಇದ್ದ ಮೇಡಮ್ ಅದೇ ಮೈಕ್ ಹೇಳಿದ್ದೆ ಅಲ್ವಾ ಇವಾಗ ಬಿಟ್ರೆ ಅಲ್ಲ ಫೋನಲ್ಲಿ ಮಾತಾಡೋದು ಏನಿಲ್ಲ ಕಳಿಸಿ ಚೆಕ್ ಮಾಡಿ ಅವರು ಹೊಸ ಕೋರ್ಟ್ ಶಿಫ್ಟ್ ಆದಾಗ ಏನ್ ನೋಡ್ಕೊಳ್ಳೋದು ಏನ್ ಬಿಡೋದು ಅಂತ ಎಲ್ಲ ಆಗೋದು ಸರಿ ನಾನು ಏರ್ಗೋ ಎಸ್ಗೋ ಹೇಳ್ತಿದ್ದೀನಿ ಸುಮ್ಮನೆ ಅಟೆಂಡ್ ಮಾಡಲ್ಲ ಕರಿತೀನಿ ಹಿರಿಯರ್ ಹೇಳಿ ಸುಮ್ಮನೆ ಆಗ್ಬಿಡ್ತಾರೆ ಯಾರನ್ನ ಮಾಡ್ತೀನಿ ನೋಡಿ ಇದೊಂದು ಹಾಕೊಡ್ಬೇಕು ಆ ಕಡೆಗೆ ಯಾವ್ದು ಮಾಡಲ್ಲ ಯಾರದು ಅಕೌಂಟ್ಸ್ಗೆ ಯಾರೆಲ್ಲ ಈಗ ಒಂದೊಂದು ಫೈಲ್ಗೂ ಹೇಳ್ತಾರಲ್ಲ ಯಾಕೆ ಟೈಮಲ್ಲಿ ಮಾಡಿಸ್ತೀವಿ ಅಂತ ಹೇಳಿ ಎಲ್ಲದಕ್ಕೂ ತಲೆ ಕೆಡಿಸ್ಕೋಬೇಕು ತಲೆ ಕೆಡಿಸ್ಕೊಂಡು ಮಾಡಿರ್ತೀವಿ ಆದ್ರೂ
ಇದು
ಹೌದು
ಇಲ್ಲೇ ಇದಲ್ಲ ಫೈಲು ಕೊಟ್ಟಿಲ್ಲ ತಾನೆ. ಬೇಕು 3119 2200. ಯಾಕೆ ನಾನು ಹಿಂಗ್ ಮಾಡ್ಬೇಕಲ್ಲ. ಇದೆ 2200 ಇದೆ. ನಾಗರಾಜ್ ಬನ್ನಿ ಬೇಡ. ನಾಗರಾಜ್ ಇದೆ ಬನ್ನಿ. ಇದೆ ಹುಡುಕ್ತೀರಾ ಅಂತ ಹೇಳಿದ್ರೆ 54 ಆದ್ಮೇಲೆ ಯಾವ್ದು ಪಾಸ್ ಅವರು 54 ಆದ್ಮೇಲೆ 40 36 ಹೇಳಿ ಸರ್.
69
ಎಲ್ಲ ಮುಗ್ದೋಯ್ತು ಸರ್ ಇಷ್ಟೇ. ಇಲ್ಲ ಪಾಸ್ ಅವರಾಗಿದೆ ಮಧ್ಯಾಹ್ನ. ಸರಿ ಸರಿ. ಫೈಲ್ ಯಾವಾದ್ರು ಜಾಸ್ತಿ ಏನಾದ್ರು ಕೊಟ್ಟಿದ್ರಲ್ಲ ಬೇರೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ? ನನ್ ಕಣ್ಣಿಗೆ ಯಾವ್ದು ಅದು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್. ಇನ್ನೊಂದ್ಸತಿ ಲಿಸ್ಟ್ ಚೆಕ್ ಮಾಡಿ ಈಗ ಯಾವ್ದು ಲೆವೆನ್ ಆದ್ಮೇಲೆ 4 5 53 56 40 ಆದ್ಮೇಲೆ 54 55 ನಾಗರಾಜ್ ಅವರು ಮೈಕೋರ್ ಬಂದ್ರೆ ನಾಗರಾಜ್ Nagraj? ಈ ಸೌಂಡ್ ಬಾಕ್ಸ್ ಇದೆಯಲ್ಲ ಇದು ಆ ಕಡೆ ಹೋಗ್ಬೇಕು ಬೇಡ ಆ ಕಡೆ
Adita madam. ನೋಡಿ ಈಗ ನೋಡಿ ಈ ವೈಫ್ ಅಂದ್ರೆ ಬರ್ಬೇಕಂತೆ ಮೇಡಮ್ ಇದು ಆಮೇಲೆ ಬರ್ಬೇಕು ಇದು ಕನೆಕ್ಟ್ ಆಗ್ತಾನಂತೆ ಅದ್ರ ಸೌಂಡ್ಗಳು ಬರ್ತಾನಂತೆ ಆಮೇಲೆ ಇದು ಈ ಮೈಕ್ ಬಂದು ಇಲ್ಲಿಗೆ ಬರ್ಬೇಕು ಯಾವ ಮೈಕ್ ಇದು ಸ್ಪೀಕರ್ ಈ ಸ್ಪೀಕರ್ ಇಲ್ಲಿಗೆ ಬರ್ಬೇಕಂತ ಅಲ್ಲಿಗೆ ಯಾಕೆ ಬರ್ಬೇಕು ಸಾಹೇಬ್ರ ಅವಾಗಲೇ ಹಾಕ್ಕೊಟ್ಟಲ್ಲ ಹಂಗೆ ಇತ್ತು
ಇದು ಈ ಕಡೆ
ಸಿಟ್ಟಿಂಗ್ ಇತ್ತೆ ಇವತ್ತು.
ಕೇಳಿಸಲ್ವಂತೆ ಅದು ಆ ಸ್ಪೀಕರ್ ಇಲ್ಲಿ ಬರ್ಬೇಕಂತೆ. ಅವು ಎರಡು ಸ್ಪೀಕರ್ ಕಲೆಕ್ಷನ್ ಇದು ಸೌಂಡ್ ಕೇಳಿಸ್ತಲ್ವಂತೆ. ಈ ಮೈಕ್ ಇಲ್ಲಿ ಬರ್ಬೇಕಂತೆ. ಇದು ಕನೆಕ್ಟ್ ಆಗ್ತಲ್ವಂತೆ.
ಅವ್ರ ಬೈಕ್ ಎಲ್ಲಿದ್ದೀವಿ ಇದು ಎಲ್ಲಿದ್ದೀವಿ ಬೈಕ್ ಯಾವುದು
ಆ ಮೈಕ್ ಸಾಹೇಬ್ರಿಗೆ ಇರ್ತಿತ್ತು. ಅದು ಬೇಡ ಅಂತ ಈಗ ಹೋಗಿ ಬಡಪ್ ಸರ್ ಹತ್ರ ಹೋಗಕ್ಕೆ ಅಲ್ಲಿ ಬೇಕಂತ.
ಇಲ್ಲ ಕಣೋರ್ಲಿ
ನಾವ್ ಹಾಕಿದ್ರೆ ನೆನ್ನೆ ತಾನೇ ಶಿಫ್ಟ್ ಆಗಿದ್ದೀವಿ. ಅದ್ರಿಂದನೂ ಹಂಗೆ ಇತ್ತು.
ಯಾವ್ದು ಬರ್ತಾರೆ
ವರ್ಕ್ ಆಗ್ತದ ಈ ಸೂತ್ರ ಆ ಸೂತ್ರ
ಇಲ್ಲಿ ಬೇಕಾದ ಇದು ಈಗ ವೈರ್ ಇಟ್ಕೊಳ್ಳೋಣ.
ಇಲ್ಲಿ ಬರ್ರಿ.
ಈ ಚಾಕ್ ಇದ್ರೆ ಕೊಡಲಿ. ಮೊದಲು ಸ್ಪೀಕರ್ ಈ ಕಡೆ ಬೇಕಾದ್ರು ಈ ಕಡೆ ಇದು ಸ್ಪೀಕರ್ ಈ ಕಡೆ ಬೇಕಂತಾರೆ.
What officer? What officer? So notice ಇಲ್ಲ
ಮಂಜು ಈಗ ಸ್ಪೀಕರ್ ಹಾಕಬೇಕು.
ಹಾ ಸರ್,
ಸ್ಪೀಕರ್ ಇಲ್ಲಿರಲ್ಲ
ಮೇಡಮ್ 33 ಪಾಸ್ ಆಗಿಲ್ಲ ಮೇಡಮ್. ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಲಿಸ್ಟ್ ಮೇಡಮ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಅದು ಬೀಗ್ ಏನಾಯ್ತು? ರಿಕ್ಯೂಸ್ ಆಗಿದೆ. ಹೌದು ಮಾಡಿದ್ರು.
ಏನಾಗಿದೆ ಅದು ತೊಂದ್ರೆ?
ಸ್ಪೀಕರ್ ಈ ಕಡೆ ಬೇಕಲ್ಲ
ಹಾ ಈ ಕಡೆ ಬೇಕು. ಹೌದಾ, ಪೈಪ್ ಬೇರೆ ಹಾಕ್ಬಿಟ್ಟಿದ್ರು, ಎತ್ತಿಡಕ್ಕೂ ಆಗ್ಲಿಲ್ಲ. ಅಲ್ಲಿರೋ ಸ್ಪೀಕರ್ ಅಲ್ಲೂ ಬರುತ್ತೆ sound.
ಬರುತ್ತೆ ಮೇಡಮ್, ಕಡಿಮೆ ಆಯ್ತು ಬರುತ್ತೆ ಈಗ.
ಈಗ ಅದು ಸೆಟ್ ಮಾಡಿದೀರಾ ಅಂದ್ರೆ? ಆಕ್ಟಿವ್ ಎಲ್ಲ ಕೊಡ್ತೀರಾ ಹಾಕೊಳ್ಳಿ ಕನ್ನಡತನ ಕೈಗಿಂತ ಕೊಂತಿದೆ.
ಈಗ ಆದಷ್ಟು ಕ್ಲಾಸ್ ಅಲ್ಲಿದ್ದಲ್ಲ ಮಕ್ಕಳಿಗೆ ಹೇಳ್ಕೊಂಡು ಹೋಗ್ತಾರೆ.
ಫಿಟ್ಟಿಂಗ್ ಇದೆ ಮುಂದೆ ಈಗ ಮುಂದು ಫಿಟ್ಟಿಂಗ್ ಇದೆ ಈಗ
ಇದೆಯಲ್ಲ ಸರ್ ಇದ್ದಾರೆ ಮಾಡಕ್ಕೆ ಬರ್ತಾರೆ. ಏಳು ನಾಲ್ಕು ನಾಲ್ಕು 8 ಡಿಸ್ಪೋಸ್ ಹಾಕು 9 ಪಾಸ್ ಓವರ್ 10 14 4 11 ಪಾಸ್ ಓವರ್ 12 ಪಿಕಪ್ 10 4 ನೋಟಿಸ್ 10 13 6 4 14 43 15 10 3 16 23 17 6 4 18 6 3 19 ಅದನ್ನು ಗೊತ್ತಾಗಿಲ್ಲ ಅದನ್ನು ಅದು ಕನ್ಫ್ಯೂಸ್ ಆಗುತ್ತೆ. ಆಮೇಲೆ ಗೊತ್ತಿಲ್ಲ ಅರ್ಜೆಂಟ್ ಅಂತ ಹಾಕ್ತೀನಿ ಅಷ್ಟೇ.
ಅದೇ ಆ ಕ್ಯಾಲೆಂಡರ್
ಇಲ್ಲ ನಾನು ಅರ್ಜೆಂಟ್ ಹಾಕಿದ್ದೀನಿ, ಡೌಟ್ ಹಾಕಿದ್ದೀನಿ.
ಆ ಕ್ಯಾಲೆಂಡರ್
ಅರ್ಜೆಂಟ್ ಹಾಕಿದ್ದೀನಿ
ನೋಡಿ
6 4 ಬರ್ತೀನಿ 4 ಆಗಲ್ಲ 19 20 33 21 33 14 22 33 23 63 24 pass over 24 25 pass over 26 33 27 dismiss 28 20 29 dismiss 30 43 31 43 32 63 30 pass over 34 35 43 36 pass over 37 43 38 43 39 43 40 pass over 41 63 42 43 43 43 44 13 10 3 45 25 correct 46 ಇಲ್ಲಿಂದ ಡೌಟ್ 46 47 48 43 49 33 50 70 51 83 52 53 53 54 55
ಅಲ್ಲಿದೆ
56
ಅಲ್ಲ ಅವರು ಅಂತ ಮಾಡಿ
ಪಾಸ್ ಆಗುಂತ ಆಯ್ತು. ಆಮೇಲೆ
ಹೌದಾ First on matters. Number 1, serial number 2. Is Shekhar Shetty.
Shekhar Shetty, Mr. Anil Shetty. None appears for the petitioner, though called twice, if none were to appear for the next day. This was released on 14th March.
Serial number 5. M. Shivaprakash.
Same order.
Manu MP.
So Manu. Under the caption, dismissal for non-passer.
Serial number 9.
Same order.
11. M. Nagesh.
Same order.
24.
Where is Mr. Mohan Bhatt? ಫೋನ್ ಮಾಡ್ಲಿಲ್ವಾ?
ಇಲ್ಲ
ನಿಮ್ಗೆ ಹೇಳಿದಲ್ಲ ಮೋಹನ್ ಭಟ್ಗೂ ಒಂದು ಫೋನ್ ಮಾಡ್ಬಿಡಿ ಅಂತ.
ಇಲ್ಲ ನಮ್ಮ ಕಾಂಟ್ಯಾಕ್ಟ್ ನಮ್ಮಲ್ಲಿ ಇಲ್ಲ ಸರ್.
Don't have.
It's only a formal party, I think.
Formal part, not written.
What I want to do with my lord, he is also putting on the same, whatever the petitioner is there. It's an endorsement challenge, for annexure, yes, my lord.
Mohan Bhatt is up. Respond number 3. Yes.
Annexure, yes, my lord. Page number 60.
Page number
60, ink page number
60. 60 is annexure J to a plan. Annexure
Plan.
yes, sir.
Plan.
Plan Baker
Plan is that annexure
J.
J and K, plan and license.
Other page 60 then. You want to refer to annexure yes.
Annexure, yes, my lord. Lost annexure.
Yes is page 81.
Page number 60 is what I have at annexure S.
You don't have the translated copies probably. So
Yes.
subsequent translated copies have been added, number of pages have increased.
Yes.
It may not be, Mr. Omkarappa also has the same set. Only we have a different set.
Yes.
Yes.
So as far as this annexure yes is concerned, my lord, it is an endorsement given by the second respondent chief officer with respect to the third respondent has given an application before the second respondent for transfer of CASA in her name in view of the sale certificate issued in her favor in respect of some site. For that, they have not accepted for our application on the ground that there is no such site and she has lodged a complaint before the Loka Adalat.
Loka Adalat.
Sorry, Loka Ayukt. Upalayukt has conducted the inquiry.
Side jurisdiction. Loka.
Sorry, ma'am.
Yes.
So what they said that whatever the site which I have purchased from my vendor is concerned, it was so a sale certificate has been issued by the chief officer for the town municipality, Ulalkere. That has been say as per the sale certificate, the kata has been affected in the name of my vendor.
Sale certificate only, sale deed agilva.
Sale certificate they have issued. Based on the sale certificate, the value is at the time in the year 1970. The value is 5,000 rupees. So
more than 100 rupees registration vehicle.
But yeah, so there are some exemptions, my lord. I will come into that. As far as that is concerned, sale certificate has been issued based on kata has been affected in the name of my vendor's husband. He is also no more. And after his death, my lord, his wife and son have sold the property in my favor. So as far as that is the portion of property, he has been allotted 60 by 30, my lord. Out of it, 20 by 30 has been purchased by the petitioner herein. So as far as that is concerned, my lord, the kata has been affected by the chief officer municipality. What has happened, my lord, subsequent to that, my lord, the court state which is adjacent to that property, my lord, measuring about that 20 by 6 feet, my lord, only 6 feet by 30. That is
You purchased 20 by 30.
Yes, my lord.
So ಉಳಿದಿದ್ದು 40/30 ಇರಬೇಕು.
That
Remaining should be 40/30.
that I have not purchased.
Yes.
The remaining portion, there is some portion is was there, and Akupatra has been issued by the town municipality. It took a portion, 6/20 million. So that portion is concerned, my lord, an Akupatra has been issued by the town municipality. So based on that, my lord, Khata is also affected in my favor. And thereafter, my lord, after the assessing the property for tax, my lord, town panchayati has given the assessment extract. And based on that, my lord, I have applied for the putting up construction for the property which I have purchased, and Akupatra has been issued, my lord. At that time, my lord, the chief officer has sought for the legal opinion from his counsel. And the legal opinion is also given. Based on that, my lord, plan and license has been issued by the town municipality. At that time, the respondent number 3 has lodged a complaint saying that I have also purchased the property under a sale certificate from the same municipality. And over in the petitioner is putting up construction. So for that, my lord, no, it is already granted, and also a sale certificate is issued, and accordingly, he is putting up the construction. And now, then, my lord, the respondent.
Hundreds of sales certificates issued, Mr. Omkarappa, without a registration same day.
That's what, my lord. Yes.
It is not a public document.
As far as that is concerned, my lord, if the value of the property is more than 100 rupees, my lord, under the Registration Act, under section 17, my lord, it is compulsorily registrable. But last week, kindly peruse, there are some exception to that.
Yes. Exception under which act?
Section 17, subclass 1D, my lord. Registration Act.
17(1)(d).
17(1)(d), my lord.
Yes.
There are some exceptions. Nothing in clause B and C of subsection 1 applies to wherein my subclass 7 is concerned. Any grant of immovable property by the government or any certificate of sale granted to the purchaser, that is toll, my lord, subclass 12. Any certificate of sale granted to the purchaser of any property sold by public auction by a civil or revenue officer. In our present case, my lord, the property has been sold under public auction.
A public auction.
Yes, ma'am.
So your purchase was by way of public auction?
Yes, ma'am. That's what the sale certificate shows that.
Where is the advertisement for public auction?
Pardon, ma'am?
Where is the advertisement for public auction?
There is the sale certificate itself, my lord.
Where is the advertisement for public auction? Sale certificate and 100 things could be sent because this appears to be fraudulent.
Yes, sir.
So there is somebody sitting there manufacturing sale certificates.
May I read the sale certificate, next year, AML type of.
There is somebody sitting there manufacturing sale certificates. Anything could be the contents.
As far as
Only Ibra inna jasti agide idu. Anymore.
In fact, Kodalkere has been a peculiar situation, my lord. In 89 to 1994, my lord, 4 presidents, with 6 years, my lord, with 3 to 4 presidents, they have executed Hakupatras and sale certificates. My lord, they are not the concerned officer to even issue it. No approval, with no resolution which is passed, my lord, in the Kodalkere municipality, my lord. Plus, they have to take sanction from the Zilla Panchayat. Even government sanction is also not taken. So these Hakupatras are executed left, right, and center.
Then what?
Real approval has to be taken from the government.
Yes. No, they have not taken.
They are
What
not.
are you doing?
There has to be done.
By whom? They're sitting there manufacturing this and contents of it, public auction and bury it.
But it is about 44 years back, my lord.
We have the advertisement of public auction, Mr. Anand. If we have the advertisement, then we can look into it. If the very document which is doubtful contains something, that cannot be looked into to make that valid. Validity cannot be on the contents of an invalid document.
Even as far as the permission, prior permission is concerned, my lord, section 72 subclass 2, I read.
Yes.
No free grant of movable property, whatever may be its value. No grant for an offset price and no lease for a term exceeding 5 years. And no sale or other transfer of immovable property exceeding 25,000 rupees in value shall be valid unless the previous sanction of the government is over. Here in present case,
5,000.
the property value is less than 25.
Now when was your grant according to you?
1970 million.
What was the position of that particular provision in 1970?
500 rupees.
We're reading the provision as it exists today.
Yes, ma'am.
What was the provision in 1970?
That provision is. But as far as that is concerned, my lord, here is a case. At that time, they have permitted, subject to permission from the government. That is there in the recital, my lord. Subject to permission.
We don't know.
Sold it.
We don't know whether it is that your client is cheated or whether this has happened in your collusion, in your client's collusion. What we'll direct is for the inquiry to be conducted, because this is 4 presidents have done this with the submission being made, who had no authority to do so. So you're basically, they are being manufacturing.
All those 4 presidents are no more, my lord. They are already dead.
No more.
About 50 years back, my lord, this has happened.
Still, that will not entitle them to claim
that is
land.
No, but at least if there's an inquiry and a report submitted, the rights of the parties will be determined. Avoid unnecessary litigation between the parties and let there be an inquiry to ascertain which is there and let the report be published as to who has a right over the property or not. If at all there is a public auction, yes, they will have. If there is no public auction and there's a manufacturer sitting in the office of the president, then that should have no value. Why?
In the case, my lord, present case is concerned. About 44 years back, the sales certificate is challenged after 44 years. Their contested because one of that is the respondent number 3 here. He has sought for transfer of kata in her name. Whatever sales certificate in her favor is given. She has not taken any kata till 44 years. In the year 1980, according to her, same footing is also standing there. She has given an application.
Who gave, who paid, what happened, let's find out. Who is the person to carry out the inquiry and submit a report?
Inquiry, DC would be appropriate. In fact, my lord, there were 2 other separate matters, my lord, in 2014. My lord, Hodalkere Town Panchayat, my lord, they wrote it to DC saying this is the fraud which is played for several years and the names of the officers were also called out. My lord, I will, tomorrow, day after, my lord, I'll provide that endorsement and notice what we requested. Those were also challenged in other set of petition. And most of the disputes in Hodalkere, my lord, pertains to Khata certificate, Khata extract and Eastwatu. And my lord, another 3-4 matters, my lord, last week, one matter had come up where, my lord, Lokayukta, also, my lord, there was a complaint filed, land grabbing court, my lord. A complaint was filed, my lord, to say that 4 petitioners in that property, my lord, had got the land illegally. That was confirmed. That order is also, my lord, stayed by this honorable court way back in 2015. My lord, I'll collect all these case numbers and I'll, my lord, these matters may be listed together.
All these can be
listed together.
They are pending.
They're pending, my lord. They're pending.
When will you give the numbers?
Not about 2-3 days time, my lord, because there are various years from 2014 till 2021 that are quite. Or next week, I'll provide all the details.
For respond number 2, submit that there are several other conflicting matters named blank. Registry direct connect the said matters and relist on 13. You give the list.
Yes, ma'am.
That
30.
Number 25. Counsel of the court.
J. Manand to the respond number 7, delete the name of the S.C. Shivramu as that appears to respond number 7. None appears for the petitioner, though for twice. Several of the complaints have also not been made. If none were to appear for the petitioner, we just on 40.
33.
CEO Mangalore, yeah. How CEO is it?
Only government is
Government is
answering party.
Please respond number.
They are formal parties, my lord. Jilla Parishad. Order is passed by the first respondent.
Ashok Naik from Dakshina Kannada.
Ashok Naik is directly to respond number 3. What is this impeding application?
I filed production of documents
IA1 for production, IA2
and impeding the deputy commissioner, because during the pendency they proceeded further to conduct election. At that point of time, I moved the application and I took up the matter to the division bench also. In fact, there was a stay. Later, division bench has passed an order. The effect that elections cannot be stopped. Whatever grievance you suggested before this.
So you want the deputy commissioner to be a party?
Not required. Not required.
You are not pressing.
I am not pressing.
Counsel for the petitioner submit that he does not press IA2 of 2017. Hence IA2 of 2017 is dismissed, is not pressed.
43A, invoking 43A, they have disqualified me. Earlier, the allegation made is
ready.
I am ready now.
Yes.
Petitioner, my lord, earlier we got elected as member of Harekala Gram Panchayat. Initially, Annexure B, my lord, Annexure B, that is 2010. First tenure was for 5 years, my lord, up to 2014.
Page?
Page 41, Annexure B, my lord, ink page 23. This is the Chunavana Pramana Patra. So he was a member. Second time again he got elected. Annexure C, page 25, please. 5/6/2015. Annexure D notice, page 27. Annexure D notice came to be issued against the petitioner, stating that he had committed certain misconduct in the year 2013-14, that is previous tenure. When in that particular point of time, no inquiry was initiated. Second time he became the member, and just may read more of that notice, Annexure D. Mangalore Taluk Harekala Gram Panchayatina ಸದಸ್ಯರಾಗಿದ್ದು ವಾಸ್ತವ್ಯಕ್ಕೆ ಯೋಗ್ಯವಾದ ಸ್ವಂತ ಮನೆ ಹೊಂದಿದ್ದರೂ ತನ್ನ ಅಧಿಕಾರವನ್ನು ದುರುಪಯೋಗ ಪಡಿಸಿಕೊಂಡು 2013-14ರಲ್ಲಿ ಇಂದಿರಾ ಆವಾಸ್ ಯೋಜನೆಯಡಿ ಮನೆ ಮಂಜೂರಾತಿ ಪಡೆದುಕೊಂಡಿರುತ್ತೀರಿ ಹಾಗೂ ಹರೇಕಳ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಧ್ಯಕ್ಷರಾದ ನೀವು ಸದರಿ ಸದಸ್ಯರ ಎಲ್ಲಾ ಅವ್ಯವಹಾರಗಳಿಗೆ ಸಹಕರಿಸಿ ಅನರ್ಹ ವ್ಯಕ್ತಿಯನ್ನು ವಸತಿ ಯೋಜನೆಗೆ ಆಯ್ಕೆ ಮಾಡಲು ನೆರವಾಗುವುದು ಮತ್ತು ಈ ಹಿಂದೆ ಸದರಿಯವರಿಗೆ ವಸತಿ ಸೌಲಭ್ಯ ನೀಡಿದ್ದರೂ ಎರಡನೇ ಬಾರಿ ವಸತಿ ಯೋಜನೆಯನ್ನು ಮಂಜೂರು ಮಾಡಿ ದುರ್ನಡತೆ ಎಸಗಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ ಎಂದು ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಯವರು ಸೊ ತಾವುಗಳು why you can't be disqualified. For this, my lord, I gave a reply via Annexure E, my lord. I contended it's not my sole decision. It was the decision taken in the meeting of the panchayat. Second thing is, ಯಾರಿಗೆ to whom the house was allotted, ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ದೇವಕಿಯವರ ಮನೆ ಚಿಕ್ಕದಾಗಿದೆ ಮತ್ತು ಅವರು ಯೋಜನೆ ಅರ್ಹರು ಎಂದು ನನ್ನ ಅಭಿಪ್ರಾಯ. So this is the reply. After this reply, my lord, the Annexure A came to be passed, my lord, disqualifying the petitioner from the membership of the Harekala Gram Panchayat under 43A. Annexure A, page 17 is the operating portion. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ my first principal contention, my lord, no independent inquiry was conducted with regard to the allegations made. Mohandas Shetty, that is the petitioner, was the president and the beneficiary was one among the members. And the decision was taken in the meeting of the all members have unanimously accepted that this benefit she is entitled. So they have clubbed the thing. I mean, they can't they can't proceed against.
You have been elected for the term 2015.
Second time. This allegation refers to first time.
From the second term is from 2015 to 2000.
2000. In the internet, they have removed them.
So you are removed on 2000?
By annexure A, page 17, 26/12/2016. After hardly 6 months in the second tenure.
That term is also complained.
Now that term is also virtually, now the writ petition may become infectious, but a stigma is attached on me. Because of now 6 years, there is whoever is expelled or terminated, the section 11 of the Panchayat Raj Act puts a bar that he can't contest election for another 6 years. That 6-year bar is also owner, I can contest. But my lord, my submission, my lord, this action itself is very wrong because no independent inquiry was conducted. They have mixed the issue. Devaki and this petitioner, they have mixed. Separate inquiry was not. And second thing is, they have punished me for this period. Well, in this, 43A, they invoke for the second time. There is no allegation as such against me in the second tenure. So this is my contention, my lord. And I have clearly stated in my reply, she is entitled and it is see, I have not caused any loss to the government action. That is one thing. Then, my lord, I contended in my writ petition that second term, you can't remove me from membership for the whatever allegation, whatever misconduct alleged to have been happened in the earlier. In this regard, my lords, I will pass on, my lords. These are the 3 judgments. I mean, this Irgantaya judgment, my lord, sorry, Irgantappa alias Irgantappa, this is the division bench judgment, my lord. ILR 2003. Here, my lord, may read last paragraph, last para 6, my lord. As far as main issue is concerned, we have very carefully applied our minds to the provisions of section 43A. It is true that this section empowers the government, and that too for good reasons, to inquire into different heads and shades of misconduct committed by elected representatives of the panchayat. And if the result of the inquiry is adverse, which disqualifies the candidate to remove the person from office, the legislature has for good reasons circumscribed the ambit and scope of section 43A, and after looking at these provisions in relation to several other similar provisions, we find that it could be extremely hazardous to accept the argument put forward by the original petitioner, namely that different acts of misconduct which may have been committed in relation to other issues prior to the date of assumption of office can also form the subject matter of inquiry under the section 43A. We are not prepared to do any violence to the section or for that matter to go against the legislative intent, for the simple reason that having regard to the general situation that is prevalent in relation to these bodies, or for that matter all elected bodies, where there are rivalries and hostilities, it would open virtually a Pandora's box, giving rise to complaints or anything under the sun committed in relation to all sorts of situations at any point of time, and the result would be virtually disastrous. This section is limited to situations that arise in relation to the period of time when the candidate has held office, and those are the parameters which a court will have to enforce. It is in this background that we need to interpret section 43A as clearly limiting the act of misconduct to those committed only after the candidate has assumed office and during the tenure in office. Issues related to corrupt practices, misconduct or other illegalities, even with regard to the election, will have to be dealt with separately. The Act itself makes provision under section 19 and 20 for taking action. As far as these situations are concerned, there is also enough scope in appropriate cases for the High Court to exercise jurisdiction under Article 226 of the Constitution. If the situation is so warrants, the cause of action in the present petition was confined to the complaint filed by the present petition, respondent number 1 under section 43A of the Act, and in our considered view, the complaint was misconceived. Insofar as section 43A will have no application to the present charges, we make it clear that these observations are with regard to the present proceeding, which are limited to the interpretation of the present section, and that they shall have no other bearing on any other proceedings. Having regard to the aforesaid findings, the appeal succeeds. We set aside the order passed by the learned single judge. In the circumstances of the case, there shall be no order as to cast. My lord, here is a person complaint. Here, person who is complaint is the CEO. CEO, the very notice itself is illegal because Annexure D is issued in the year second tenure.
Yes.
However, my lord, this honorable court, my lord, single judge of this honorable court took a little different view in another matter, my lord, the CP 8988 of 2016. Second judgment, my lord, is in Kripananda's case. Here, my lord, Lordship Kothari, Justice Kothari had taken a little different view, and they have he simply said irrespective of tenures.
There are 15 and 16.
There are 15 and 16. 14, 15 and
15.
it may be noteworthy to point out that
there was no inquiry, not it was remanded back before the authority. Also can be done if, if no opportunity was given. My lords may remand it because 43A6 says even former Adhyaksha or Upadhyaksha is if he is guilty of misconduct, 43A is attracts 43A sub plus 6 million. If a former Adhyaksha or Upadhyaksha or a former member of the Gram Panchayati has been accused or proven guilt for misconduct or misappropriation in any inquiry, if the petitioner says that there is no inquiry has been held, as per this decision, and a new inquiry can be conducted by the appropriate authority and it has can be remanded. Because you can't escape from the stigma, because he himself has admitted that there was a house to that member Millard. He is himself
small.
Small. But she is as per the guidelines, if it is for houseless people, the scheme is provided. Intentionally, he knows that there is a house and he has the.
What is small will be relative.
No, that's what not. He has though it may be little arrogant way of submitting his reply, he had given that reply. And may I read Milord for a moment?
You read it. You read it.
Yeah, reply given by the petitioner, Milord. Annexure E. ನಾನು ಯಾವ Annexure E page 30. ನಾನು ಯಾವ ಅವ್ಯವಹಾರವನ್ನು ಪಂಚಾಯತ್ನಲ್ಲಿ ಮಾಡಿಲ್ಲ. ಸದರಿ ಸದಸ್ಯರಿಗೆ ಎಲ್ಲಾ ಸದಸ್ಯರುಗಳ ಒಪ್ಪಿಗೆಯ ಮೇರೆಗೆ ಇಂದಿರಾ ಆವಾಸ್ ಯೋಜನೆಯಡಿಯಲ್ಲಿ ಮನೆ ಮಂಜೂರಾತಿ ಮಾಡಲು ಒಪ್ಪಿಗೆ ನೀಡಿರುತ್ತೇನೆ. ಇವರಿಗೆ ಈ ಹಿಂದೆ ವಸತಿ ಸೌಲಭ್ಯ ಯೋಜನೆ ಮಂಜೂರು ಆಗಿಲ್ಲ, ಇದು ಸುಳ್ಳು ಆರೋಪ ಮಾಡಿದ್ದೀರಿ. ನನಗೆ ದುರ್ನಡತೆ ಎಂಬುದು ಗೊತ್ತಿಲ್ಲ. ನಾನು ದೇವರ ದಯೆಯಿಂದ ಒಳ್ಳೆ ನಡತೆಯಿಂದ ಜೀವನ ಸಾಗಿಸುತ್ತಿದ್ದೇನೆ. ನನಗೆ ದುರ್ನಡತೆಯಿಂದ, ಬೇಜವಾಬ್ದಾರಿಯಿಂದ ಮತ್ತು ಅವ್ಯವಹಾರದಿಂದ ಜೀವನ ನಡೆಸಬೇಕೆಂದಿಲ್ಲ. ನಾನು ನನ್ನ ಕೈಯಿಂದಲೇ ನನ್ನ ವಾರ್ಡ್ಗೆ ಪಂಚಾಯತ್ ಸದಸ್ಯನಾಗಿ ಚುನಾಯಿತಗೊಂಡ ಅಂದ್ರೆ 5 ವರ್ಷಗಳಿಂದ ಕುಡಿಯುವ ನೀರಿನ ವ್ಯವಸ್ಥೆ ಮಾಡಿರುತ್ತೇನೆ. ನನಗೆ ದೇವರು ಕೊಟ್ಟ ಆಸ್ತಿ ಇದೆ. ಪಂಚಾಯತಿಯಿಂದ ದುಡ್ಡು ಮಾಡಬೇಕೆಂಬುದಿಲ್ಲ. ಶ್ರೀಮತಿ ದೇವಕಿ ಅವರು ಕೋಮ್ ಅನ್ನಿ ಪೂಜಾರಿ ಮನೆ ಚಿಕ್ಕದಾಗಿದೆ ಮತ್ತು ಅವರು ಈ ಯೋಜನೆ ಅರ್ಹರು ಎಂದು ನನ್ನ ಅಭಿಪ್ರಾಯ. ಹಾಗೆ ಎಲ್ಲಾ ವಿಮರ್ಶಿಸಿ ನೋಡಿದಾಗ ಇದಕ್ಕಿಂತ ಮುಂಚಿತವಾಗಿ ಯೋಜನೆ ಸೌಲಭ್ಯವನ್ನು ಪಡೆದ ಫಲಾನುಭವಿಗಳು ನಿಮ್ಮ ಲೆಕ್ಕದಲ್ಲಿ ಅರ್ಹರಾಗುವುದಿಲ್ಲ. ಶ್ರೀಮತಿ ದೇವಕಿಯವರ ಮೇಲೆ ಮಾಡಿರುವ ಆರೋಪವು ರಾಜಕೀಯ ಪ್ರೇರಿತವಾಗಿರುತ್ತದೆ ಎಂದು ನನ್ನ ಅನಿಸಿಕೆ. ವಾಟ್ he said, I never did any misconduct. Whatever as entire ಅದೇ ಎಲ್ಲಾ ಸದಸ್ಯರು ಒಪ್ಪಿದ್ಮೇಲೆ ನಾನು ಮಾಡಿದ್ದೀನಿ. ದಟ್ ಈಸ್ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್.
ಆಮೇಲೆ ನಿಮ್ಗೆ ಎನ್ಕ್ವೈರಿ ಸಿಕ್ಕಿಲ್ಲ?
ಹೌದು, ಎನ್ಕ್ವೈರಿ ಮಾಡ್ಬೋದಿತ್ತು. ದೇರ್ ವಾಸ್ ನೋ ಫುಲ್ ಫ್ಲೆಡ್ಜ್ ಎನ್ಕ್ವೈರಿ. ಮೈ ಪ್ರಿನ್ಸಿಪಲ್ ಕಂಟೆನ್ಷನ್ ಇಸ್ ದಿಸ್. ನೀವು ದೇವಕಿ ಮೇಲೆ ಸಪರೇಟ್ ಎನ್ಕ್ವೈರಿ ಮಾಡಬೇಕು, ಮೋಹನ್ ದಾಸ್ ದಿಸ್ ಪೆಟಿಷನರ್ ಮೇಲೆ ಸಪರೇಟ್ ಎನ್ಕ್ವೈರಿ ಮಾಡಬೇಕು. ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಡನ್ ಇಟ್. ದೇ ಹ್ಯಾವ್ ಮಿಕ್ಸ್ ದ ಟೂ ಥಿಂಗ್ಸ್ ಅಂಡ್ ದೇ ಹ್ಯಾವ್ ಕಮ್ ಟು ದಿಸ್
ಸಪರೇಟ್ ಎನ್ಕ್ವೈರಿ ಹೆಂಗ್ ಬರಲ್ಲ?
ಅಲ್ಲ, ಸಪರೇಟ್ ಎನ್ಕ್ವೈರಿ ಮಾಡಿಲ್ಲ ಅವರು. ಅಂದ್ರೆ ಇಬ್ರಿಗೂ
ಸಪರೇಟ್ ಎನ್ಕ್ವೈರಿ ಮಾಡಿ. What separate inquiry?
Whatever allegation, see, against him, allegation is that you have sanctioned. Against her, allegation is that though she is, I mean, according to them, not entitled, but she had applied and obtained the benefit. So here, I have not misappropriated any amount. Whatever amount to be given from the department or that Vasati Yojana.
You simply decide and remand it. To give you an opportunity to
that may be.
Even that small house also are earlier allotted to her, my lord.
My lord, one more judgment, my lord, I relayed this 2012 for Supreme Court.
Not required.
That judgment.
The petitioner is before this court for the following. The grievance of the petitioner, that the petitioner being elected member of the Arekala Grama Panchayat during the elections held in the month of May 2010 was re-elected for the re-elected in the elections held on June 2015, alleging that in the first term from 2010 to 2015, the petitioner, while functioning as president of the Arekala Grama Panchayat, has helped another member of the same Grama Panchayat named Devaki to obtain sanction of the house, even though she already had a house. The petitioner has been disqualified without following the principles of natural justice, inasmuch as on a show cause notice having been issued and the reply being submitted by the petitioner without providing an opportunity to the petitioner to meet the evidence against him. The impugned order at Annexure S dated Annexure A dated 26/12/2016 has been passed, disqualifying from the post of the president of the Panchayat. In this regard, learned counsel for the petitioner relies upon the decision in WP number 8988 of 2016, dated 30th November, and more particularly para. Thereof. A parallel of this decision would also indicate, and in that background, in the other background, is submitted the petition is required to be allowed, and the order quashed. The internal and AG appearing for the state would submit that there are serious grievances which have been serious allegations against the petitioner. Inasmuch as there being an admission on part of the petitioner himself that he said Devaki had already an house which had been allotted. Allotment of another house was impermissible. And it is on the basis of the admission made that the order, impugned order, has been passed. The exercise of powers under section 43A for removal of the elected president or elected member from membership is a draconian power which is required to be exercised only in circumstances which require it to be so exercised after following due procedure, more particularly the principles of national justice. In the present case, there is no dispute that only a show cause notice was issued. The reply given was not acceptable to respond number 2, and thereafter, petitioner has been held to be disqualified to hold the post of objection. After the reply has been issued, there is no facility or opportunity provided to the petitioner to place his defense on record and also to meet the allegations made against him, if necessary, by cross-examining the concerned witnesses against him. This going to the root of the matter, there being a violation of the principles of national justice, I want to consider opinion that the impugned order cannot be sustained. As such, I pass the following order. This petition is allowed. The Seshara is issued. Impugned order passed by second respondent bearing number so-and-so dated 26/12/2016 at Annexure A is hereby quashed. The matter is remitted to the second respondent for fresh consideration in accordance with law and in accordance with the observation made here and above. The order having been passed in presence of both the counsels, the petitioner shall be present before the second respondent on 20th March at 2:30 p.m.
Little later, madam, I have to communicate.
27th March at 2:30 p.m. without requirement of any further notice. The second respondent shall comply with the above observation and pass a reasoned order within a period of 3 months thereafter. Naik.
For respond number 3.
Mr. Naik. Mr. N.R. Naik, CL number 36.
Please, madam.
Working that. Could I mic work?
Yes, madam.
Kersta ideyalla, Mr. Naik?
ಕೇಳಿಸ್ತಾ ಇದೆ sir.
Lord, the petition was filed by the petitioner. This was the endorsement issued by the respondent number 3, that is Arthikara Town Municipal, my lord. Last date of hearing, Disama Court was directed us to file an affidavit on what action was taken against the other encroachers, my lord. That effect, my lord, I filed an affidavit telling that, my lord, he issued a notice to the PDO to give reason why you issued the katas in encroached sites. Here, my lord, subject matter is, my lord, the present petitioner is seeking a CA site to change the kata in his name. His claiming is purchased from the
We have issued a notice to the PDO.
Yes, my lord.
The allegation is in the CA side. in the alleged CSI, there are 3 other construction which have happened.
Yes.
And only insofar as the construction of the petitioner is, it's been rejected, saying that it's a CSI.
Clear.
So what action have you taken as regards if you claim it to be a CSI? Those 3 constructions are also illegal. That is what this court seems to have directed on the earlier.
Yes, my lord. Yes.
But what you have done is you have issued one notice to the PDO. What about those 3 people?
My lord, earlier it is under the Gram Panchayat. The PDO is the authority who issued the.
About people who have a house there.
My lord, we are still like those persons are not come to us for change their kata. It is still in the Panchayat kata.
Without changing the kata, anybody can construct on the civil.
No, it was constructed long back. My lord. We are extended our limits. CMC is extended their limits.
Are those construction on a civic community side?
Yes, my lord. Yes, my lord. When this case was filed, he came before us to change kata. The CMC gave asked an opinion on the advocate. Then only we got the.
Not about the petitioner. The other 3 that Mr. Naik is.
Those persons' kata is not yet changed, my lord.
The counsel, we are asking you for the 3rd time. It's not kata we are asking. Is the construction ಕೇಳಿ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ಬೇಕಂದ್ರೆ ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ಬೇಕು ಅದು 3 ಬೇರೆ ಸೈಟ್ಗಳಿದಾವಲ್ಲ ಅಲ್ಲಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗಿರೋದು ನಾಯಕ್ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಅದು ಸಿವಿಕ್ ಕಮ್ಯುನಿಟಿ ಸೈಟ್ ಅಲ್ಲಿ ಇದೆ ಅಂತ ಅವ್ರದ್ದು ಸಿವಿಕ್ ಕಮ್ಯುನಿಟಿ ಸೈಟ್ ಇದೆ ಅಂತ ರಿಜೆಕ್ಟ್ ಮಾಡಿದೀರಾ ನೀವು ಬಟ್ ಬಾಕಿ 3 ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಇದೆ ಏನ್ ಆಕ್ಷನ್ ತಗೊಂಡಿಲ್ಲ ನೀವು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಏನಾದ್ರು ಆಕ್ಷನ್ ತಗೊಂಡಿದ್ದೀರಾ
ಅದಕ್ಕೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಕ್ ಹೇಳಿದೀನಿ
ಯಾರಿಗೆ
CMC
ಯಾರಿಗೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡ್ತೀರಾ
they have to issue the constructed people my lord notice issue ಮಾಡಿ they have to call them
ಅದು ನಿಮ್ಮ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಏನು ಹೇಳಿಲ್ವೇ
that to filing because my lord
ಇವಾಗಿರೋ PDO ಏನು ಪ್ರಯೋಜನ ಇಲ್ಲ
correct my lord because he is the person who issued license and this
don't try to make him a scapegoat. He has nothing to do with what has happened much earlier.
I already gave an instruction, my lord, telling that issue notice to all those persons and call them and find out what is.
Your affidavit doesn't even say that.
No, I will find better after.
Your affidavit only says you have issued a notice to the PDO. Why he has not issued the that to Mr. Naik?
I will find better.
Counsel for response 364 and is granted.
2 weeks. Yes, our seeker had to seek instructions there and
instructions?
our notice issue ಮಾಡ್ಸ ಆಮೇಲೆ ಫೈಲ್ ಮಾಡಿ.
Mobile phone, email.
Please, sir, next week.
Don't ask for too much time. Takes for a week's time to file a better affidavit.
Please.
Released on 13th March.
Much of this.
Please.
Number 40.
Better affidavit indicating what is the action taken against each to have built their houses on the civil community.
Number 40.
Lord, serial number 47, my lord, same issue, the same issues, my lord.
Talking about I was not present.
47.
47.
It has gone to 6-3.
6-3. And otherwise, but I am ready. Both of us are ready, my lord.
My friend is
7 not in 47.
47
is a different.
No, he is not there.
I am not there in 47.
But issue is the same.
Same issues.
That whether a clinic run in a whether a clinic run by a doctor in his house, whether
Requires
not the trade license.
Trade license.
So this also is
That
the
is
same.
all the question.
Then we'll connect this and take it up on 6.
Yes.
Connect 40 to 57 and relist on 6.
6.
So all 3 are as regarded. In one, there was no license granted, one license was granted and cancelled. Nimmal enagide?
Lord, not granted.
Not
I have not applied it.
What we heard in the morning is 47, no license was granted. 47.1 license was initially granted and then it was cancelled.
Lord, in my case, I have not obtained the license at all. And they are insisting on the license.
They are insisting on the license, he didn't obtain this.
We have obtained this. Almost, my lord, the short point is whether it is required or not.
We have it from.
Please.
Let's finish all. Unless you want to argue this, please, that will become applicable.
Only thing, sixth I have.
But we will have the benefit of others, my other colleagues also.
Sixth I have.
Sixth, you have.
Little inconvenience.
Have it on 7.
7th, please, my lord. I'll be grateful.
I don't know 7. 47.
Grateful.
Figure number 54. DS Venkata Subbarao.
So Soumya ji.
Lordship may connect it because otherwise the same
Yes, we are
confusion
still
might occur.
We are
40 and
connected.
47.
We are connected.
Okay, great.
So, bro, where is Mr. Soumya?
Tried calling,
Not Texas.
Soumya ji or access. ಇಲ್ಲೇ
Yes,
ಇರ್ತಾರೆ.
yes.
ಹಾ, ಬಂದ್ರಲ್ಲ ಈಗ ಏನ್ ಸೌಮ್ಯ ಜಿ ಅವರ ನೀವು
Number simple ಇಲ್ಲ ಅದು.
ಬೆಳ್ಳಿಯ ಪರದ ಮೇಲೆ ಬರ್ತೀರಾ ನಂಬರ್ ಇಲ್ವಾ ಅವ್ರದ್ದು
My colleague tried, my lord, he said it is not accessible.
ಅಲ್ಲ ಯು ಹ್ಯಾವ್ ಇಸ್ ಮೊಬೈಲ್ ನಂಬರ್ ಯು ಡೋಂಟ್
My colleague has, I don't have.
ಯು ಹ್ಯಾವ್ ರಿಜಿಸ್ಟರ್ಡ್ ಆನ್ ದಿ ಅಡ್ವೊಕೇಟ್ಸ್ ಪೋರ್ಟಲ್
Yes.
ಮಿಸ್ಟರ್ ಸೌಮ್ಯ ಜಿ
Yes. The order without jurisdiction.
ಆರ್ಡರ್ ಬರ್ರಣ ನೀವು ಹ್ಯಾವ್ ಯು ರಿಜಿಸ್ಟರ್ಡ್ ಆನ್ ದಿ ಅಡ್ವೊಕೇಟ್ಸ್ ಪೋರ್ಟಲ್
ಇಲ್ಲ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ, ಅದೇ ಒಳ್ಳೇದು. ಮಾಡ್ಲಿಲ್ಲ, ಮಾಡ್ತೀನಿ.
ನಂಬರ್ ಸಿಕ್ಕಿಲ್ಲ ಅಂತ ಪಾಪ ಸುಬ್ರಾವ್.
ಹೌದು, ಸರಿ ಆಯ್ತು, ಮಾಡ್ತೀನಿ. ಸರಿ ಸಾರಿ, ಮಾಡ್ಲಿಲ್ಲ, ಮಾಡ್ತೀನಿ.
ನಾಳೆ ಕೇಳ್ತೀವಿ.
ನಾನು ನಾಳೆ ಒಂದ್ 2 ದಿವಸ ಕೊಡಿ ಟೈಮ್, ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಮಾಡ್ಲಿಕ್ಕೆ, ಅದೇ ಮಾಡಿ.
ಆಯ್ತು, ಥರ್ಸ್ಡೇ ಕೇಳ್ತೀವಿ, ಥರ್ಸ್ಡೇ ಒಳಗೆ ರೆಡಿ.
ಆಯ್ತು ಒಳ್ಳೆ. ಇದು ಆರ್ಡರ್ ಇಸ್ ವಿದೌಟ್ ಜ್ಯುರಿಡಿಕ್ಷನ್.
ವಿತೌಟ್ ಜ್ಯುರಿಡಿಕ್ಷನ್.
ಅಧ್ಯಕ್ಷ ಅವ್ರು ತಾಲೂಕ್ ಪಂಚಾಯತ್, ಅಧ್ಯಕ್ಷ ಅವ್ರು ಜಿಲ್ಲಾ ಪಂಚಾಯತ್, ಅವ್ರಿಗೆ ಇಬ್ಬರಿಗೂ ಅಧಿಕಾರ ಇಲ್ಲ.
ಯಾರಿಗೂ ಹೋಗ್ಬೇಕು?
ಅವ್ರು ಎಪಿಲ್ ಏನಾದ್ರು ಇದ್ರೆ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆಫೀಸರ್ ತಾಲೂಕ್ ಪಂಚಾಯತ್ 216 ಹಾಕಿ.
In fact, fifth respondent, Lord invokes 237, my lord, the first ever that Khata in respect of an improved property in my name. Rather, my father's name was challenged. Invoking 237, my lord, before the Taluk Adhyaksh. That was, my lord, the order was, my lord, the Khata was, my lord, disturbed. Therefore, I was in appeal before this Zilla. That's how it is. Initially, my lord, 237 was invoked by fifth respondent.
ಅಲ್ಲ 237 216 ಅಲ್ಲೇ ಹಾಕ್ಬೇಕು. ಇದು ಇಬ್ಬರಿಗೂ ಕೂಡ ಪವರ್ ಇಲ್ಲ.
ಇಬ್ಬರಿಗೂ ಪವರ್ ಇಲ್ಲ.
Correct.
ಪವರ್ ಇಲ್ಲ. ದಿ ಬೋತ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ದ ತಾಲೂಕ್ ಪಂಚಾಯತ್ ಅಂಡ್ ಅಧ್ಯಕ್ಷ ತಾಲೂಕ್ ಪಂಚಾಯತ್, ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ has to set aside.
So what we'll do is we'll set aside these orders, reserving liberty to fifth respondent to initiate appropriate proceeding under the appropriate provision.
Please.
Yes.
Subject to, in fact, there's a civil decree in my favor. Shall be taken into consideration.
This is on a technicality.
I understand.
So if merits are available, both of you can agitate.
Very good.
The petitioner is before this court seeking for the following news. The reason to the petitioner is that the orders at Annexure A, Article number 7 of 2000, 16/1/2014, and the order date 7/3/2002, passed by the President, Taluka Panchayat, L, without as neither of them has power 237. Number ಏನು?
Appeal, my lord. Annexure J 9.
77.
237 power is only to suspend the resolution. ಅದು something to prohibit in public interest. ಅದೀಗ ಅಮೆಂಡ್ಮೆಂಟ್ ಕೂಡ ಆಗಿದೆ. ಅಮೆಂಡ್ಮೆಂಟ್ ಕೂಡ ಬರೋದಿಲ್ಲ ಅಂತ ಇದೆ. ಬೇಕು ಸೀರೀಸ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಂಡ್ ಹೈಕೋರ್ಟ್ ಇಲ್ಲ.
237 to cancel
Supreme Court judgment. Hello, sir.
the other issues also. Cancel the
ಆದೇಶ ಅಂತಿದೆ. Page 73.
Page
77. ಆದೇಶ. ಆದೇಶ.
Cancelling the khata issued by the
Nagamangala Taluk Panchayat.
Respondent that is by respondent number 4 in favor of Kempegoda Yaro,
Father of the petition, deceased.
father of the petitioner.
But as on this day, he was not there. As on that order, Melody was not there.
He has already
He is already.
father of the petitioner who had not
I understand.
petitioner who had already deceased prior to the order being passed. Condition of Shri J.S. Venkat Subbarao, learned counsel for the petitioner, is there is no such powers vested with the respondents under section 237 for cancellation if at all appropriate proceedings are to be taken under section 269. The same not having been done, these powers could not have been exercised by the authorities. That submit that the delay which has been caused in challenging said order is on account of no particular information being made available to the petitioner about the said matter being taken up. In as much as on several occasions there were no sittings of respondent number 2. The petitioner did not even know the next dates, nor did his power know the next dates. Furthermore, the order passed by second respondent was not even communicated to the petitioner. It is only when the fifth respondent sought to assert his right on the property that the petitioner came to know of the claim made by fifth respondent of the impugned order, and it is thereafter that certified copies were obtained and the other petition filed. None appears for respondent number 5. None appears for respondent number 5, though called twice, and the matter is taken up for consideration. Shri B.J. Somyaji, learned counsel for respondent number 2 and 4, fairly concedes that respondent number 2 and 4 did not have the powers to pass annexure A and L. Similarly, the submission made by learned AGA for respondent number 1. The peril of section 237 only indicates that the powers vested are only for the purpose of suspension of any particular action pending inquiry relating thereto, and does not confer any power to cancel a kata which has already been issued. Thus, neither respond number 2 nor respond number 4 could have
Respond number 3,
respond number
2 and 3.
3, sorry. Respond number 3 for president could have passed the interim orders. As such, the same orders would have to be decided. This court has also been coming across several criminal proceedings in this jurisdiction where the quasi-judicial authorities are not holding sittings in a proper and required manner, nor are the information being made available to the litigants and the lawyers. This is one more case in reference, in as much as the impugned order dated
26/12.
7/3/2002 not to the knowledge of the petitioner. Dated 16/1/2014 was not to the knowledge of the petitioner until he made inquiries thereto and obtained the same in the year 2016. The proceedings having gone on before the respond number 2, as could be gathered from Annexure N, indicates that on most dates the matter was adjourned. On the ground that respond number 2 was busy with administrative work or otherwise. The peril of the order sheet at Annexure N gives rise to a very sad situation where the matter, though listed on 10/5/2002, adjourned to 15/6/2002, then thereafter to 18/7/2002, 17/8/2002, 19/9/2002, 19/10/2002, 28/11/2002, 4/1/2003, 13/2/2003, 28/3, 35/2003, 10/7, 19/7, 29/8, 17/10, 21/11, 19/12, 7/2004, 26/3, 5/6, 31/7 was adjourned on all those dates since the presiding officer was otherwise busy. On 9/9/2004, there was a sitting, but nothing much happened. And then 10/2004, 10/12/2004, 22/1/2004, 26/2/2005, 8/4/2005, 28/5/2005, 8/7, 8/7, when the matter was adjourned. 8/4 only. When the matter was adjourned because the presiding officer was otherwise. When the matter was adjourned on 28/5/2005, when the counsel was not present, the matter was adjourned to 8/7. On 8/7, again, the counsel was not present, hence the matter was adjourned to 11/8. With lack of time, the matter was adjourned to 15/4. The counsel was not present and thereafter adjourned to 25/5/2006. On 25/5, the matter was adjourned to 1/7, 25/8, 6/10, 23/11, 29/12, 3/2, 15/3, 19/4, 26/5, 7/7. And the matter was adjourned because the counsel was otherwise busy. On 16/8, since the counsel was not present, the matter was adjourned. 2/22. And then adjourned to 26/10, 1/12/2007, 17/1, 23/2, 29, 15/5, 19/6, 19/7, 23/8, 26/9, 31/10, 4/12, 9/1, 2009, 5/2/2009, 3/2/4, 12/6, 10/7, 7/8, 10/9, 10, 3/12.
2014,
What is this?
almost took 12 years.
ಅದು ನಾನು ಹೇಳ ಸ್ವಾಮಿ,
ಹೇಳಿ.
10 ವರ್ಷ ಹಿಂದೆ ದಿ ಸ್ಟ್ರಿಕ್ಚರ್ಸ್ ಅದನ್ನ ಅವ್ರಿಗೆ ಲೆಟರ್ ಬರ್ದೆ ಮಾಡಬೇಡಿ ಅಂತೇಳಿ. ಸ್ವಲ್ಪ ಸಮಯ ಸುಮ್ಮನೆ ಇದ್ರು, ಮತ್ತೆ ಇದು ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ರು. ಇವನಲ್ಲಿ ಅಡ್ವೊಕೇಟ್ಸ್ ಕೂಡ ಇದನ್ನು ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರೆ.
ಅಡ್ವೊಕೇಟ್ ಹೋಗಿ ಎಲ್ಲ ಕ್ಲೈಂಟ್ಗಳೆಲ್ಲ ಹೋಗಿ ಅಲ್ಲಿ ಕಾಯ್ಕೊಂಡು
ಇಲ್ಲ, ಅಲ್ಲಿ ಅಡ್ವೊಕೇಟ್ಸ್ ಗೊತ್ತಿದೆ ಕಾನೂನು, ಆದ್ರೂ ಕೂಡ ಅವರೇ ಇದನ್ನು ಪ್ರೋತ್ಸಾಹ ಮಾಡ್ತಾ ಇದ್ರು. ಹಾಗೆ ತಾಪತ್ರರಾಗಿತ್ತು.
ಎಲ್ಲ ಡೇಟ್ ಬರ್ಕೊಳ್ಳಿ.
WP number 22708 of 2011.
3 page ಅಂದ್ರೆ this is actually from 97 to 111.
ಅದೇ ಅದು WP number 22708 of 2011 ಅಲ್ಲಿ ಇವರಿಗೆಲ್ಲ ದೇ ರಿಕ್ವೈರ್ ಎಜುಕೇಶನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ ಹೇಳಿ ಮಾಡಿದ್ದಾರೆ. ಅದ್ರ ಮೇಲೆ ಲೆಟರ್ ಬರ್ದೆ, ಏನ್ ಪ್ರಯೋಜನ ಆಗಲಿ.
On 13/12/2013, noticing that the counsel was not present, the matter was posted for orders, and thereafter orders seems to have been passed on 16/1/2014. The above would not indicate any information having been conveyed either to the petitioner or his advocates about the adjournment. On most occasions, it is the presiding officer who has been otherwise busy and not interested in discharging his quasi-judicial functions and did not discharge his quasi-judicial functions. And when the petitioner was adjourned, the matter was posted for orders. Quasi-judicial authorities are also discharging. These administrative authorities are also discharging quasi-judicial functions. It is but required that the administrative authorities give equal, if not more, prominence to quasi-judicial functions where the rights of the citizens are affected. Like in this case, when an order has been passed without jurisdiction, not only without jurisdiction, but also without information to citizen of the people. It is but required that suitable directions are issued to the RDPR, Principal Secretary, Panchayati Raj, Rural Development and Panchayati Raj, to institute an appropriate system and methodology to web host all case proceedings, including the daily orders and judgments, on the relevant website of that particular authority in a similar manner as that done by this court, as also the district courts. So that, yes.
ಇವ್ರಿಗೆ ಪವರ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ಅದೆಲ್ಲ ಅಗತ್ಯ ಇಲ್ಲ ಅಂತ ಕಾಣ್ತದೆ. ಯಾಕಂದ್ರೆ ದೇ ಹ್ಯಾವ್ ನೋ ಜುರಿಡಿಕ್ಷನ್
ಇದ್ರಲ್ಲಿ ಈ ಪರ್ಟಿಕ್ಯುಲರ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ, ಬಟ್ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಇದ್ದೇ ಇರತ್ತಲ್ಲ.
ಇಲ್ಲ, ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಇಲ್ಲ. ಖಾತಾ ಸಂಬಂಧಪಟ್ಟದ್ದು ಇಲ್ಲವೇ ಇಲ್ಲ. ಹೆಚ್ಚಿನದೆಲ್ಲ ಖಾತಾ ಸಂಬಂಧಪಟ್ಟದೆ.
ಬೇರೆ ಯಾವ ಮ್ಯಾಟರ್ ಆದ್ರೆ ಹಿಂಗೆ 100 ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ನಾಟ್ ಸಿಟ್ಟಿಂಗ್.
ಅದು WP ನಂಬರ್ 22708 of 2011 ಅಲ್ಲಿ WP ನಂಬರ್ 22708 of 2011 ಅಲ್ಲಿ ಅದೇ ತರ ಮಾಡಿದ್ರು. ದೇ ರಿಕ್ವೈರ್ ಟ್ರೈನಿಂಗ್ ಅಂತೆಲ್ಲ ಬರ್ತಿತ್ತು. ಏನ್ ಪ್ರಯೋಜನ ಆಗಿದೆ? ಹೌದೌದು, ಅದೇ ನಾನು ಹೇಳಿದೆ. 10 ವರ್ಷ ಮೊದ್ಲೇ ನಾನೇ ಲೆಟರ್ ಬರ್ದೆ, ಅದ್ರ ಪ್ರಯೋಜನ ಆಗಲಿಲ್ಲ.
is done by the district courts. All details of the proceedings, including the dates on which the matter is posted, the daily orders which have been passed, evidence if any recorded, directions if any issued, as also the final judgment which has been passed would be required to be uploaded on the relevant website. The necessary arrangements to be made to inform the litigant as also the advocate by SMS and or email, if email ID is provided, about the orders which have been passed in the matter, like that done by this court. Whenever there is any adjournment which is made by the Procedural authority, the detailed reasoning to be given as to why the matter is being adjourned, rather than a laconic statement that the presiding officer is otherwise busy in administrative functions. A suitable monitoring system to be established by the Principal Secretary, Department of Rural Development and Panchayati Raj, to monitor the progress of all quasi-judicial proceedings before the authorities coming under his jurisdiction. A comprehensive report, detailed project plan, as also a detailed action taken report to be submitted within a period of 4 weeks from today. Wherein AGA is directed to bring to notice of the Principal Secretary, RDPI, about the seriousness of the matter. More so in this particular matter, where proceedings were pending from the year 2002 to 2014, where more than 100 adjournments have been granted. Nearly 100 adjournments have been granted on account of the presiding officer being otherwise engaged in administrative functions. The state of Karnataka to also, the Principal Secretary to also explore the possibility of appointing separate set of persons to deal with quasi-judicial functions who will not be required to discharge administrative functions. So those long pending matters can be completed at the earliest. In this day and age, when the courts have also installed hybrid hearings through video conferencing, the Principal Secretary to explore the possibility of making available similar facilities at all quasi-judicial authorities, so as to enable easy access to the citizens of the country, easy access to justice to the citizens of the country. In view of the above, I pass the following order. Writ petition is allowed. The impugned order dated 16/1/2014 passed by the second respondent in appeal number 7 of 2002-3 of annexure A, and as also the impugned order dated 7/3/2002 passed by the third respondent at annexure L are hereby quashed. Liberty is however reserved to the fifth respondent to initiate such proceedings as may be available strictly in accordance with law.
Right.
Though the above petition is disposed of, relist on 31st year end varatala, relist on 6th April.
Please.
For filing compliance.
Complaints.
Number 55.
55 appear for respondent number 10, my lord. I had requested for an adjournment in the morning session.
Yes, Mr. Devraj.
This case only for the.
Short point or bandre ant ಹೇಳಿದ್ರೆ ಅವ್ರು ಬಂದಿಲ್ಲ.
In the meanwhile, I'll file my objections also, my lord.
Respondent number 10 seeks bond is granted 2 weeks time to file a statement of. Yes, MS Devraju has entered appeals for respondent number 2 to 4. Delete B Purandara as that appearing for respondent number 2 to 4. None appears for the petitioner, though called twice. If none were to appear for the petitioner on the next date of hearing, so and so released on 16th March.
Much obliged. my lord.
Number 56. Manmohan PM.
Mr. Manmohan.
Next issue. 7th March. 7th March.
7th. 56 at the request of Sri Shivramu released on 7th March.
Alesha Archie.
62. None appears for the petitioner, though called twice.
I pay for the
16th, Mr. Sumit.
66. Prabhakar Rao.
66.
My lords, in this matter, I appear for the petitioner counsel. He is not in town, so he requested for 1 week adjournment, my lords.
Objections ಹಾಕಿದ್ದೀರಾ?
I fail, my
Already. 66 at the request of the council for the relist on 7/3, it is made clear that no further adjournment will be granted.
Much obliged.
67. S.V. Prakash.
Yes,
Lord, I am here, my lord.
Yes, but where is Mr. Gangadharappa?
That is, I couldn't contact him. I made effort.
Will contact.
The matter lies in narrow compass, my lord. I lost my land. I want alternative, my lord, a site to be allotted.
None appears for the respondent number 4.
4.
Though called twice. If none were to appear for the respondent number 4, instead of hearing, the matter would be taken up for consideration in their absence on the basis of submission made by the counsel for petitioner, who is present and ready to address his arguments today. Relist on 7th March.
7th, my lord.
Okay.
Other person name wrongly mentioned. Only mistake is that. Most I think
Our ilva.
Gangadharappa spelling mistake ಆಗಿದೆ.
Oh, spelling mistake ಆಗಿದೆ. ಅವರ ಹೆಸರು ಹೊಡೆದ ಒಳ್ಳೇದಾಯ್ತು ನೀವು ನೋಡಿದ್ದು. ಹಂಗೆ ಅರ್ಥ ಆಗಲ್ಲ ಇದು. ಗಂಗಾಧರಪ್ಪ ಆಗೋದು. 67 registry is directed to correct the name of the counsel for respondent number 4 as printed in the cause list. Released on 7th March.
69. Avan Kumar.
68, Mr. Prashant, you are not there in the morning.
Let's appeal for the petitioner, my lord. 69.
Just a moment, just a moment. Counsel for respondent number 2 is expired. So they will appoint a new counsel. We have adjourned the matter to
10th April.
10th.
10th April.
Court
Court notice.
Since you are not there, we directed notice. No, that's what we are asking. You are always present. So how come you are absent? Learned AG accepts notice for respondent number 3. Srinidhi V had entered appeals for respondent number 2. Delete the name of Sri Pawan Kumar as that appearing for respondent number 2. Counsel for respondent number 2 has expired. The nodal officer requests for 2 weeks' time to appoint a new counsel. Relist on 27th March. Shri Prashant Rao, party in person, he is present in person before this court. 27. Yes, 69.
For the rest,
Yes, madam, what happened?
Your Lordship, we have preferred an appeal against the order. In fact, Your Lordship, the appeal is listed today.
My lords, I appeal for the petitioner, my lords. We are on caveat, my lords. We have filed caveat. No copy has been served by the respondent advocate, my lords.
No copy has been served. Then no order will be passed there.
Please, my lords.
Your Lordship, I was not aware of the caveat. If that is the case, I will have to check, Your Lordship. If we have received the copy, I am not very sure. But in fact, the matter has been listed today, Your Lordship.
That counsel for the respondent 1 to 3 submit that an appeal is being filed, which is listed today. He seeks for a short accommodation. We list on 20th March.
This month.
234 matter. CC Vinita.
Mandamus at the same time.
Mandamus.
And
Mandamus 230 and it was.
no. There is construction. I sought for a stay of the construction. Your Lordship may kindly see the petitioners are the photographs. Your Lordship may kindly see, Your Lordship.
Yes.
And at page number 39.
39.
Yes, please. The road dead end where the entrance of the petitioner's property. Your Lordship may kindly see page number 39. And
cul-de-sac. You are at the end of the property, end of the road.
Yes, please, Your Lordship. And I'm not aware that what construction they are doing. I'm going and approaching them. The contractor is, you go and approach the BBMP. And I go to the BBMP office, zonal ward office, Your Lordship, and the zonal office. And they are not ready to take my representation and not they ready to explain what is that. And only they are going ahead with the construction and saying that the MLA or corporation has told us to go. And there is absolutely no clear clue of what is the construction. And there is no way at all for me to enter my house.
Counsel for the petitioner submits that the respondents are putting up construction in front of the house of the petitioner. And despite repeated requests made by the petitioner to ascertain the nature of construction and the reason for construction, the same has not been made known to the petitioner, nor are the representations being given by the petitioner taken on record by the respondent.
And I have sent it through post also, Your Lordship. I produced a annexure D.
Annexure?
D.
Yeah, thus
Page number 35.
constraining petitioner to on 24/2/2023, despite which no action has been taken and the construction is going on.
Saturday, Sunday, they have totally dug up in the photographs, Your Lordship, with the date.
The third construction being expedited on Saturday and Sunday.
Yes, Your
advantage of the holidays. In view thereof, the respondent number 1 and 2 are restrained from putting up any construction till the next date of hearing. Counsel for the this MR sanction directed to accept interest for respondents. Counsel for the petitioner to serve a copy of the petition along with annexures by end of day today and file acknowledgement with the registry by tomorrow morning. Relist on 2nd March.
Hand delivery.
Respondent shall act on the printout of the uploaded copy without insisting on a certified copy.
Please.